Minister said something which is so true. And I think now during COVID-19, it's even worse because many women lost their source of income, informal source of income. Women would be doing nails, pedicure and was that pedicure and manicure. Now, because of COVID, we are afraid to go and do our nails. Then that means they lost their source of income. They do hair. People were afraid to do their hair. I sat for how many months with my hair during COVID-19 because I was afraid. There are many businesses that they were involved in, which helped them to be able to look after their children. But all that source of income, it went down because of COVID-19. And then in that process, respondents who are responsible for payment of maintenance would then go to the court and apply that the maintenance order be cancelled. Why should it be cancelled? Why is it not suspended? Minister said maintenance is mostly the only source. However, it's so unreliable. Sometimes it comes, sometimes it doesn't come. I think we need to do the RDP, Reconstruction and Development Program of the mind of the parents who are supposed to pay their maintenance. Because it's not about this woman that we're fighting with. It's about your child. Love your child. I think also we need to start a campaign where men need to be seen with their children, men who love their children, to show that this is how you love your child. Doesn't matter whether the mother is in the picture or not, but love your child, pay maintenance rather than clog the courts. Just take your child, go buy clothes, whatever, give them money, and all of you are happy. No one will waste your time by going to courts and all those things. And by the way, even the traditional leaders do not pay maintenance. And in the rural areas, you find them with so many children. So now we have the acting chairperson of the National House of Traditional Leaders, Unkosikazi Mhlauli. You will hear from her. You will definitely hear from her. She will tell what needs to happen. Unkosikazi Mhlauli, over to you.
Good morning. My video is on, but I'm not sure whether you can see me, Program Director. Oh, thank you very much. Good morning, everybody. I wish I was there with you. Nyayazi bandiyakhula ukuba phakathi kwamakhosikazi. Malibongwe. Malibongwe. Program Director, Advocate Maluleke, DG at the Department of Women, Youth and People with Disabilities. Our Minister, who's always on point on the issues of women. And before going forward, Minister, let me tell you this. Never think that you have not done your work. You have done everything to make sure that women and children and people with disabilities are protected in this country, including other ministers who have been in this department. We need to applaud you for the work done. Thank you very much. And Minister Lindwe Zulu in absentia. I'm here with Josisi Dumedi from the National House of Traditional and Question Leaders, who is also the chairperson of the Gender Committee. She is also joining virtually. Fellow presenters and everybody who's here. And let me first congratulate women of South Africa for launching the African Women Leaders Network, which is going to be a vehicle to everything we are being, we are trying to achieve. Congratulations once again. I was there when you were launching. Siyabulela makhosikazi. The National House of Traditional and Khoisan Leaders is a statutory body. Apologies, Program Director, let me switch off the video because it's a little bit disturbing me with network. The National House of Traditional and Khoisan Leaders is a statutory board established in terms of Traditional and Khoisan Leaders Act 3 of 2019 for a term of 5 years, after which membership ceases and new members are elected again for 5 years. It represents aspirations of traditional communities at national level. There are also provincial houses and local houses representing aspirations of traditional communities. The mandate of these houses include working together to promote the role of traditional and Khoisan leadership within a democratic state, to promote the social well-being and welfare of communities, among other key roles. There are senior traditional leaders and head men and head women who are responsible for similar functions within their respective communities. The National House of Traditional Khoisan Leaders, in terms of committees established to fulfill the mandate of the House, we have got the Gender Committee, which is responsible for issues of youth, people with disabilities and children. The House also provides that the Act provides that the House must perform tasks that may be determined by the President or any minister that can feel that the House can assist. As we know that we have been talking about Section 20 of that Act, when we're just saying that the departments are free to ask the traditional leaders to have some work to do with them, but also assisting with resources, but in fact, coming together, we're using resources. This, therefore, honorable ministers give the mandate that traditional leaders have in the welfare of traditional communities. Traditional leaders have taken a developmental monarch approach to enable rural people to take control of their destiny, thereby dealing effectively with rural poverty, unemployment, and inequality through the optimal use and management of physical, intellectual, and natural resources. We have also launched the Invest Rural strategy. The aim is to unlock the potential of underdeveloped communities, eliminate rural poverty, reduce inequality. Program Director, we have been asked a question here. What is the role of traditional leaders in the enforcement of Maintenance Act against child maintenance payment defaulters? Currently, there's no legal instrument or legislation which empowers traditional leaders to play a direct role in enforcing the Maintenance Act, or simply put, enforcing child maintenance. Traditional leaders are not empowered by any specific legal provision to play this important role. The Traditional Courts Bill has been in limbo for many years, that which are supposed to assist us to deal with these matters, because you know that traditional leaders used to call those people who are supposed to answer or for their wrongdoings. But now, since we don't have don't have the legislation that provides for that, we can't proceed with those issues. But we do try by all means to talk to our communities. This means that traditional courts are still operating under the Black Administration Act, because we don't have the current act now. The third schedule to the Act lists offenses which may not be tried by traditional leaders. However, in the absence of legislation, as now Tubakondo, we can't say that as leaders. Traditional leaders have a responsibility toward their communities. In terms of Section 15 of the Traditional and Question Leaders Act, traditional leaders perform functions provided for in terms of customary law and customs of their communities. In this regard, traditional leaders assist the communities with dispute resolutions mechanism and apply restorative justice in child maintenance disputes. When we're talking about restorative justice program director, we're saying we are looking at making sure that the father is forced to pay the maintenance, but there must be still that friend, that link with the family of the child. We don't want that when the father is paying maintenance, now he becomes angry and he doesn't want to do anything with the family or with the child or the mother of the child. So we're playing that role, but looking at the justice, in fact, at the legal issues, what must be paid must be played by the courts. We don't interfere with those legal issues. This basically means when it comes to their attention that there is a member of the community who is not contributing to the welfare of the community, traditional leaders are able to intervene in terms of customs to ensure that the individual takes responsibility for the welfare of the child or children. The role has not been allocated as it should be, but we continue trying by all means to assist. Also, program director, in our observations, yes, we are pleased that government has developed punitive mechanism for defaulters in ensuring that we become a caring society. That we applaud that. We are also pleased that government has initiated child support grants as a way of reducing the burdens on unemployed parents or parents whose salaries do not meet the needs of their families, among other interventions. However, it has been proven that while these interventions are helpful, in many instances, they are not enough to cover basic needs such as food, clothing, shelter, and medical aid, schooling, among others. The relevant departments should work, let me come just to the recommendation in closing, because we need to come up with recommendations here. And we are aware that when talking about the defaulters, as a program director has indicated, it doesn't doesn't exclude us as traditional leaders. It includes everybody, that starting from traditional leadership, religious leaders, political leaders, all leaders. They are also part of these defaulters. Our recommendations are the relevant departments should work with traditional leaders to conduct outreach programs in traditional communities. The House has to participate in these outreach programs in order to capacitate. Also, the department must have these programs to capacitate houses and traditional leaders on the Maintenance Act and the Children's Act, specifically to ensure they understand that all parents, whether married or not, living together, separated or divorced, are required to support the financial needs of their children. This will enhance their restorative justice role in enforcing maintenance. Also, we recommend that there must be empowering legislation the empowering legislation should be finalized as a matter of agency. If this is done, traditional councils could be allocated a function of enforcing maintenance, and they would also have a register of all defaulters, which would alleviate the problem of parents traveling to urban centers and magistrates' offices to check if payments were made. Also, we recommend that relevant departments should ensure that each traditional council has posters and other material to help educate communities on Maintenance Act and associated punitive measures. Coming to closing, program director, we also recommend that in terms of custom, it takes a village to raise a child. And therefore, as traditional leaders, we are to encourage our communities to continue the communal spirit, even when the individual is creeping in. We therefore encourage relevant departments to embrace the communal approach in dealing with child maintenance in rural areas. This approach is crucial, ensuring community members hold each other accountable for abandoning their responsibilities. Finally, we invite all relevant role players to work together. As I'm coming to closing my program director, I remember very well that when we're launching the men's parliaments, we moved around the country. When we met some of the boys, because there were boys assembled, the boys were so angry about the absence of their fathers. But some were saying the mothers, they don't allow them to have a relationship with their mother, with their fathers. So we need also to address that, because also the mothers are angry. Even the other child said, when the child was asking, who is my father? And the mother said, what are you going to do with the name of your father? Whereas your father didn't even buy a 12.5 meal for you. So we needed to deal with those issues. I'm happy to be part of these discussions, Minister, looking forward to deal with these issues together, making sure that our children, they do get what is due to them, but also they are supported by both parents. Thank you very much.
Thank you, Nkosikazi Mhlauli. Before I call our next speaker, I would like to acknowledge, I think people asking themselves, she's acknowledging right at the end instead of at the beginning. I didn't want to acknowledge the people that were here because we didn't, at that time, we didn't have people from Hammanskraal. Sidibeng is still not yet here. Are they here? Those that are coming from Sidibeng. No, I've given them enough chance. Hammanskraal, I heard that they are here. Ekurhuleni is here. Just wave your hand, people from Hammanskraal. Ekurhuleni. Thank you. Yes, I wanted to acknowledge everyone when you were here, but Sidibeng, I gave them enough chance. They are not here, and Sidibeng, I think, is not that far. Again, I would like to acknowledge my Minister Maite Nkwana Mashabane. If it wasn't because of her, we wouldn't be here. Thank you, Minister, for giving us the opportunity to come and meet here. As indicated that Minister Lindiwe Zulu is not here, but we acknowledge her. I would like to acknowledge Nkosikazi Mhlauli. I think there's a way that I should call her, but having grown up in Alexander, I'm not sure, but I think Nkosikazi is enough. Also, we have Khosi Sidumedi. You are welcome, and thanks for the support. We have Miss Kamokhelo Lukubu Wilderness and Miss Josephine Peter Opita. Advocate Anthea Platt, SC. We have her here. SC means senior advocate. We have Miss Lily Tifo. We have Miss Lalita Chetty. I think she's joined virtually. She's a magistrate, ne? Lalita? Lalita? I hope she's not one of the people that are struggling to join. I'll explain that one later. Do we have Advocate Mark Morgan? Maybe he's joining virtually also. Miss Felicity Guests, she'll be presenting later. Welcome, Miss Nomsa Matsehari. Or a representative, she indicated that someone or there's someone from the National Credit Regulator, Mr. Laurie Grevenstein and his wife. Yeah, I think all the people that are supposed to present are here, all managers in the department, everyone who's attended, you are welcome. Unfortunately, Sidibeng, I waited for them. I couldn't welcome them. I couldn't welcome everyone until all the others are here. And now we will go to the Department of Justice. Department of Justice, you know, I've already raised some of the issues that as a department we have a concern with, because women call our department. Women always call our department is inundated with emails, calls, you know, all those. When women don't get maintenance, I will talk to what the magistrates are doing when they present. But with the Department of Justice, even in terms of employment of the maintenance officers, maintenance investigators, maintenance clerks, it takes too long before the matter of applying for maintenance comes to the court. Nkosikazi Mhlawuli had already indicated that yes, there are grants, but the grants are not sufficient. 350 can't buy clothes, can't pay for medical aid and all these others. So even if there's a grant, that means maintenance is still required. There are so many challenges with the Maintenance Act, even the training of the maintenance officers and the clerk, the things that they tell women when women go to court. Women then will call and say, I was in court, the clerk or the maintenance officer told me that I must reduce the maintenance, or I think I'm better, I want so much money, whatever. There's so many challenges with the Maintenance Act, but of interest today is the enforcement of the maintenance, the child maintenance payment. What is justice doing with the defaulters? Because it ends up being the responsibility of a woman who doesn't even have the powers. Women, when the emolument orders are issued, they are given to women for women to take them to the companies. The companies where they're taking them to, most of the time, they side with the person who doesn't pay maintenance, so they frustrate the women. So there are so many things that I would like the Department of Justice to address us on. Thank you very much, Advocate Petunia Sabe Matupa. You can.
I request permission to take the mask off. Minister Maite Ngwana Mashabane, esteemed parliamentarians, all protocol observed. Good morning to you all. It is a privilege for the Department of Justice to be given an opportunity to come and present at this esteemed occasion, where one of the burning issues of our nation is being tackled. We are very grateful for the invitation, Advocate Megateko Maluleke. Thank you very much. Sorry. As already stated, my name is Petunia Siabi Matupe. I am the Chief Family Advocate in the Department of Justice and Constitutional Development. Maintenance became part of the program that I lead with effect from 2018. Before I present to you, I just want to create the scenario. If anyone were to ask an artist to draw a picture of the state of maintenance in our country, we are going to end up with a product that none of us likes. It's going to be a product that is not looking very bad. If you look, just take stock of the legislation that is already in existence. I do not take away from the other innovations that are still coming to improve the environment. Just taking stock of what is already on the table. You are going to see very beautiful legislation. We stand as the envy of very many jurisdictions, including the Americans in the USA. When the group of people to people come to visit us, they do comment on the beauty of our Maintenance Act. Why then is our picture so ugly? Those are some of the issues which my presentation is going to try and tackle. But if you look outside into society, what is happening in the nutshell is the following. Effective parenting has escaped our society and our communities. Parents would rather be focusing on their own conflict and forgetting this very important person who is the child that they together brought into the world. And I think Nkosikazi touched on it towards the end of her presentation just before me. The services that we render as a department are funded from a public purse that is shrinking very, very rapidly. We are not able to catch up with the demand of services that is growing much quicker. Just have this in your mind. The purse is shrinking, the demand is growing. That is why one of the key reasons why we are sitting with this very, very ugly picture that I am going to present to you. We do acknowledge we have failed. We are not succeeding. We are not succeeding in the implementation of the Maintenance Act, because had we in the beginning costed it properly in 1998, we would have had a much bigger structure than we already have. We would have had a lot more personnel, a lot more computers, a lot more maintenance officers and maintenance investigators having Wi-Fi's and access to data that they can utilize to become more effective. Now, the picture going out there is that public servants do not want to serve the people. Public servants are insolent, public servants are rude to the people, and so on. If you sit in an environment where one person is doing the work of 4, 5, 6, 7 people alone, we understand that, human beings are human, and those weaknesses will show. The last part of the background that I wanted to give is that we also, as the state machinery, are taking too long to transcend or to transform, because when you take stock of all the legislation that is in our statute books now, you see that children are no longer the subject of parental authority. Children have become bearers of rights within their own rights. Now, some of the problems in maintenance, when you look at them, you see that we still function as though children are the subject of parental authority. And again, one of the speakers before me have mentioned that, a parent will block the right of the child to have a relationship with the other parent because of the conflict that ensues between them. Then in retaliation, the other parent will withhold the maintenance or start dodging the maintenance. On the flip side of the coin is that in the maintenance environment, we are dealing with people who are liable to pay maintenance, who first do not want to be found. And when you find them, they conceal their assets. They do everything in their power to hide their assets or make those assets to disappear, register it under trusts, register it in somebody else's name, resign from their jobs, dissipate their pensions so that nobody knows where to find them. So that is the background I just wanted to give before I go into the presentation that I want to give to you. What efforts the Department of Justice is taking to try and give effect to this. I'm not sure if my presentation is showing somewhere. My first slide, or I can share with whoever wants me to share it. I have just done a bit of the legislation analysis. But what I want to draw your attention specifically to is what I have already spoken to. Section 28(2) of our Constitution. It provides that the best interests of a child are of paramount importance in every matter that affects the child. This is a realization that both the state and the parents and society needs to make. The best interest of the child must be afforded absolute priority. If you not pay maintenance, you're compromising the best interest of your child. And that makes for very ineffective and bad parenting. And before it becomes an issue for government, what are you, the parent, doing in terms of realizing the constitutional right of your child that their best interest must take priority? I will not bore you with the rest of the legislation. As I said, if anyone wants me to share, I will share it. What we are doing as a Department of Justice so far, in our annual performance plan, we have indicators which we have committed that we will perform for the year 2021 to 2022. The first one is we are monitoring the finalization rate of maintenance cases in selected courts. Ask me why we have selected only 241 courts. I will come back to what I have already mentioned. The shrinking pairs. Not every court has got a maintenance officer. Not every court has got a maintenance investigator. So we are only able to measure our performance at those 241 courts. We have set a standard for ourselves that we will finalize the cases within 90 days from date of proper service. That means after date of proper service, that case is ready to be presented for a magistrate to adjudicate upon. That is why we give ourselves a turnaround time of 90 days. Because I always say, maintenance is an ex post facto claim. Why is it an ex post facto claim? Any person that comes through our doorpost to come and apply for maintenance has come there because something has happened. The Kumbi driver did not collect their child for a week. They opened the fridge to make lunch for their child. There was nothing in the fridge. The child is going to school without any shoes. You know, those things have already happened. So we are fully aware, we are fully conscious that maintenance is an ex post facto claim. We must act speedily. We must act efficiently, and we must give it our best. But we are only able to do it at 241 courts. In her opening remarks, the DG mentioned 200,000 applications. And I am sadly going to tell you that we have finalized only 34,000 up to the 31st of August. How does 200,000 compare to 34,000? You see that is where in between those two numbers is where the constant complaining lies. Because we have capacity to only give you 34,000 out of 200,000. The difference is the sum total of your complaints, why you are so unhappy with the Department of Justice. Right, the second thing that we are measuring in our annual performance plan is we are working on a maintenance improvement framework. As I said, maintenance came into the program of the Chief Family Advocate 3 years ago. We are fully cognizant. We are very aware of the number of complaints that are coming. So we are working on developing a maintenance improvement framework. We are alive to the fact that maintenance needs to be improved and improved yesterday. So we are busy working on that. Our framework, we have given ourselves a target to finalize it by the 31st of December of this year. The ransomware attack on the department is going to make me want to tell another story, but I will not bore you with that. It is not your problem. You come to us for services, not for our problems. But we are doing our best to catch up and deal with that. Another challenge that we find in the maintenance, I already told you about the people that do not want to be found and the people that are hiding their assets. A big chunk of maintenance respondents from our analysis come from the informal economic sector of our economy. Those people, we have realized, are undocumented. They are unbanked. We struggle a great deal to follow their money. We can just see the maintenance investigator will go and serve a notice to them or go and do whatever they need to do. They will tell you the guy lives in a double-story house. I saw this German machine and the next one and this parked in their driveway. We go into the system. Nothing. We send the maintenance investigator back, go and see why is this person so rich yet looking so poor in the credit bureau. We find the guy has got a fleet of taxis. We find that they've got a thriving tavern. They've got a thriving car wash in the township. They run the best shisanyama. If you go there Friday evening at 6 o'clock, you will not find a seat in the shisanyama. Yet they look very, very poor. We recently received a heartbreaking complaint from one of the ladies that said, this guy has not paid me maintenance for 6 years, not a black cent, yet he owns this thriving tavern in one township whose name I will not mention. Then I've got a 23-year-old son. I said to him, I mentioned the name of the tavern, and they said, Mama, why are you asking me that? What is your business now with this tavern? I said, no, you know, I work in maintenance now, Papa. I need information. He said, hey, Mama, there we wear G-Star. I don't know what is G-Star. When we go there, we wear G-Star because we sit on white couches and the girls there drink Moe. I said, what is Moe? Apparently it's a champagne that costs 8,000 rand or what. He painted a horror picture for me, being his mother. Now I can understand what this complaining mother is going through. She has not seen a black cent in 6 years. And looking at my son's face, I understood what G-Star means. He said, we wear G-Star pockets, ma'am, and the girls drink Moe. So I'll leave you to figure out for yourself what is happening there. So far, with the little that we have successfully traced of these people that I have told you about, 2,493. We could have multiplied that figure by 10 had we had the resource. Now we managed to, the latest hustle that we came across, I try to avoid telling you about our cyber attack, but it keeps coming back to my mind. The credit bureau that is assisting us in tracking these people that do not want to be found or hiding their assets has now put the brakes on us. They say, if you experience a cyber attack, you place us at the risk of legal liability because we do not know what the people that hacked your system have taken. There is the Protection of Personal Information Act, which prescribes very severe penalties for us, which can actually put us out of business if it is found that with the hacking, we lost some of the people's personal information. So we are busy renegotiating our deal with them with the assistance of our IT gurus so that the system can come back and we can rapidly increase these 2,493 people that we have traced. This we do with only 380 maintenance investigators. There are 700 odds courts in South Africa. I want to give you a picture that you see why I say we are short of people, but we are doing our best. We have only 380 maintenance investigators. These are the guys that you tell, hop into the government car, go and look at this guy's Shisanyama. Let us see if we can go to CIPCC and find something on them. Let us see if Credit Bureau can give us something on them. Let us see. And we can count some very serious successes, but we count them, unfortunately, on our one hand. The one time I've got my assistant, Miss Peter, can remind me, the one we have recovered how many millions of rands. The other poor guy, we have found that he even owns a petrol station and 3 houses in one of the reputable estates in Midrand, including Blue Valley. Those of you that are familiar with Blue Valley, you know the price of houses there. So we need to be uncovering this, but with the number of maintenance investigators that we have, we are moving at tortoise speed. And I remind you, the balance between the 200,000 applications and the numbers I am giving you is the sum total of the complaints that you are bringing to us. But again, mark you, we are alive to the problems that you have. Right, let me share with you just briefly the methods that we use. I have already alluded to the electronic tracing, which we are assisted with by a credit bureau. In that, we are able to find the businesses of these people. We are able to pick up on their credit profile. We also follow property through the deeds registry. Then we are able to find, and the one maintenance official that we have at national office has also found out that we can also go into the licensing department to find who owns which car and so on. Then we have an idea that if this person can have a 2019 Range Rover, can surely not be unable to pay a 500 rand per month for their child. So those are the efforts that we are taking. We are really, really alive to our issues. The next slide is my sad story. Our challenges, I've been talking to them intermittently. The number one is the staff shortages. And the fact that even when we measure the speed at which we finalize, we are not doing all the courts because we do not have the staff at all the courts. We are doing 241 out of the total number of courts in our country. Another thing that we have picked up, and I've already beaten Advocate Anthea Platt's ear there from the NGO Basadi ba Molao. I've beaten her ear before we started earlier. We have picked up on a severe low skills among our maintenance officers. Our maintenance officers, the majority, or if not all of them, have not had exposure to the practice of litigation. They have not had any exposure to the tactics that you use to put into place the civil remedy that you see in this beautiful act of ours. Because we can attach emoluments. Minister, we can attach people's property. We can attach, we can garnish their salaries, but that takes a little bit of, litigation tactic. You know what to prepare, what. Okay, I've been told that ke kenye le Sesothonyana ne, but ke Mopedi, so please try and understand this Limpopo tongue. Se ne ke se hlalosa ke hore re shota batho, ha rena di maintenance investigators. We are very short of maintenance investigators. Then se seng hape se re se thotse ke hore there are no skills. The maintenance investigators are about litigate, that they are not like us advocates that you know that, oh, okay, if the legislation covers me on this area, then I can prepare in this way so that I can go and argue this way, convince magistrate. So we have already started with the training. We are not qualified trainers, but we saw that as a low-hanging fruit that we can latch onto. We sat together with my team of 3, by the way, in case you wonder, in National Office, we are a team of 3 ladies trying to pull this big truck uphill. We are trying to pull it up the hill. And that is why it is going up so slowly. But take heart. We are going to get it right. Take heart, South Africans. We are going to get it right. Because after this engagement, re tlo kopanya matsogo, re tlo berekisana, re tlo thusana, the practitioners ba ba leng in private practice, ba tlo re thusa hore re kgone ho le thusa. Ba tla re trainela di maintenance officers tsa rena. Our maintenance officers e tla ba di star ko khoto. The cases tsa lena di ka se tlhole di stagnate le palla go tswela go pele la ntshwara hore ke bolela le ka accent ya Pretoria ke ke ngwana kwa Atteridgeville ke ngwana kwa Atteridgeville. Take heart, le re omanyeng. It is your right to do so, re omanyeng, but at the back of your mind hopolang hore le na le batho ba ba lwanang to win this battle. And hopefully, win. I wish by the end of this year, every problem will be out of the way. But just take heart. We are fighting. So litigation, and then I think once we this, our beautiful act will change this ugly picture that we have, because then re tlo khona ho kry di garnish order, re ka se re tlo khona ho kry di property tsa batho ba tse ba di fitlhileng, re tlo khona ho kry the unbanked and the undocumented, your taxi owner, your sponsor shop owner, re tlo tseba hore o etsa bokae ga kgwedi ene a ka khona ho thusa ngwana wa hao ka bokae ka kgwedi. Bana ba rena can continue suffering because of people ba ba fitlhang ka mokgwa ba khonang, because kana go ne re kgaogana re kwatisane o ntshabetse le jono or what or whatever se re kwatisaneng ka sona. Now the poor child o tshwanetse a suffer. Senga se kopang go lona batswadi ke hore please managing conflict between lena le di ex-partner tsa lena, because it is also the conflict the case must move slowly. Now, because you are fighting so much, there are people who are very experienced in playing the system. Itla khoto ka di 22 November. A hotle motho go kena pampiri, it's go docteng, motho wa lwala. Di control tsa rena are heavily laden. We re lebella date engwe. Okay, because you're going to be sick for 3 days, it's like the 25th of November. The roll of so now has a tlakachego. Rufa date next year May. Mwana ukai kana kwe. Transport ngwana yo ya skolong ikai kana ko e. So are we minimizing conflict so that we get better cooperation? But Minister, I'm also happy that the laws are being revised, because we also need to bring in an element, alternative dispute resolution. I do not like the term alternative. I'd rather say appropriate dispute resolution. Really say ADR. What is the best solution to this particular problem? again, if, you know, I had the magic wand, ne ke tla re bana le di-intake officers, ko di-court-o, but if we can get civil society to assist us, I'm sure we can train people. We can get unemployed graduates who can come in, but over the intake officers, tsa rena. Then we know sometimes you come into our courts, ore probleme ke maintenance. Ke mama. Come on next door. Papa is also sitting on a bench, also application form your contact. As Justice Department, Rofa, come on maintenance, Rofa tleke, Rofa stationery, Rofa court space, Rofa this. Papa ko application ya high, your contact, remove the same thing. We are wasting resources. If we banally appropriate dispute resolution, ra khona ho channela the problem it's okay, the conflict is escalated by the fact that, and I think we will, I saw you in the audience, we need some social work capacity as well in our courts. Then with that social worker here, they're able to get to the root cause of the problem. By the time we send you to a magistrate, we are asking for an effective order that is going to resolve your problem. Instead of us sitting, then how you are going to run to the domestic violence and say, then we come out with an order that says, don't come within 500 meters of her. Meantime, application contact. You get the point. So implement with the assistance of civil society. We can pick Advocate Maluleke, maybe 1 or 2 courts and pilot this intake system and see what it gives us. With proper intake and channeling these people, will we not get more effective court orders instead of us saying, don't come within 500 meters of her? Then another magistrate is sitting there with equal amount of effort. You will see the child every Friday from 8 o'clock until Sunday, 8 o'clock, and so on and so on. Now you're sitting with these 2 court orders. The one says don't come within 50 meters. The one says see the child at 8 o'clock every Friday to Sunday. Where's justice? You see, that those are the issues that are confronting us. But I think, and I am happy that I have already heard from the opening remarks and the 2 esteemed speakers that came before me that there is intention for us to take each other's hand and make this situation works. Scold us. Deliver. But remember, in the background, we are pedaling very hard to resolve these problems. We want them to be resolved. We want to serve our society. We want to improve the lives of children in this country. I thank you.
Thank you, Advocate. South Africa's family advocate. Family advocate, she has already indicated, we contribute to the case backlog. Maintenance in a case backlog. So, Harere batabelang maintenance, will deal with them. But in order for the justice system to be able to deal with them, let's remove some of the things, say the clogging the system. How clog the system? So even the major or important matters that could also set a precedent. But also, as Nakwele Hagitoma, I said, I want the fathers, you know, most of the time, Hakitama Liko Moliko Kai, Kibona Bontatenya Babanya, Nibatama Libana Babona, Obatoleba Peri Dilote Twanang, Bakatile Likate Twanang, Karen Kamulata Kirwen. Can you teach your neighbor who doesn't pay maintenance or who doesn't have time for your child? The Kore, what the advocate was saying, Kore, let's work together to raise the children. even if nako e nngwe motho ha bereke ka nnete, mara motho o tshwantse a bane le nako for ngwana gae. Ngwana o ba happy. Nkosikazi Mhlauli o itse bana ba bang ba re, when I ask my mother that I want to see my father, the mother would say no. And ngwana o gola le bitter. So from both sides, because the mother denies access, the father doesn't want to meet with the child. There's so many things, and the people that are suffering are children. I'm so happy I can say kutlwa bana ba rasa mo akidutsi mo le kutlule ngwana answer kire bana ba ba dumela ba. We're here to talk maintenance and about me ba tsamaya le bana and bana ba bang bao ha ba thole maintenance akere. So all of us should work together. But I liked what she said, that we think hore the graduates, unemployed graduates need to be used. We have linkutlile ke re na le esimo aba patalwi ba etsang ba ibitsa pro bono ba etsa ba batlo etsa mereko itseng to train not just the unemployed graduate, but even the clerks tsa ko court. Akaba abua so I understand, but nakwangwa ya court utolor the clerks do not understand akir. So di bona ba to trainiwa gore hali ya court ba khone le gore ba le guide. Rena le ba bang mo ba etsang alternative dispute by bitsa social justice gore social justice is not all about going to court. You can be able to address some things without going to court as long as li dumelane and then muto le ena stick to the agreement. Has a sticky to agreement, that's when you go there. So I'm so happy about the discussion. Kitlole fa chance ya gore ba ba batlang go botsisa dipotso before kitlo bitsa the next panel gore itlo bolela. But apparently we have a serious problem. Our IT system, when they set the virtual system, they used Teams, again, they used a webinar, but I don't know what, I'm not an IT person, so you'll bear with me. It could only accept 100 people. And we were expecting nearly, I think over 500 or even up to 1,000. So people are struggling to join. What we've done, another link has been created, but through YouTube. My concern is that some have not yet received that link. But I think if they go to YouTube and click child maintenance webinar, they might be able to access. And we have presenters that also are supposed to be in the virtual. I think they're struggling to join. That's why earlier on I was asking if Ms. Lalita Chetty was in virtual, and also Advocate Morgan. But if Advocate Morgan is not there, we have someone else who will be able to speak also. She's a sheriff, Advocate Emily Dlamini. She said she'll join virtually. I hope she's managed to join. I hope all those people who were supposed to join were able to join. But now, and then ona bua pele Kgosigadi li utlwile le ena gore na reng akere yena na bua ka magoshi na bua ka di rural areas taba ya maintenance, also gore molao wa bona for now ha o ba fe matla wa gore ba dile ka maintenance, but it doesn't mean that batho ha bana le conflict ya maintenance ha batle ko bona, batho ba ya ko bona ene ba ba thusa akere. Yeah, because look on my, but now my interest is more on the traditional leaders themselves who are not paying maintenance. But joining website more virtual. Also, I saw the deputy chairperson of the NCOP. I think there are also other parliamentary members, because we invited them. They are responsible for amending the legislation. Some of the things, if the Department of Justice doesn't initiate the amendment, they can initiate the amendment. But also, I like the part where they can call anyone to come and account. When I started, I indicated that they must call the Department of Justice to give the numbers, to say these are the people that we've sent to prison and they're in prison now, and these are the people that their property has been executed as Nansa Chokhore. e ya o executor e tšo goreng o mong motho hana a reka ntlo mara o na le koloi o na le music system o turang o na le o reka G what G-Star, o reka di G-Star, patali maintenance. Le tsona tshwantse di rekisiwe. They must also be, di tsamaya di auctioniwa, so that di tlo patala maintenance. Akere, motho ka se reke burugu ba 6,000 rand, a reke diaparo tse turang mara, a tlhole go patala 250 rand, but also le 250 rand must stop. Motho o etsang ka maintenance, ha se grant ra e utlwa, but maintenance ya 250, no, there must be a minimum amount that people must pay ya maintenance. But at the same time, I can remove if habereki, aribuleleng go thusana jwang. But ntwe nngwe gape, if motho apply la gore maintenance canceliwe because habereki, it must be suspended, not cancelled. Because if it's cancelled, it means a woman must go and start afresh and take all those years. And then Bauba resigning. Ha o tseba hore monna o resignile ke ntwe nantsa e bua advocate, but because babang ba resigna ka bana ba tlo patala maintenance mathela ko court ba botse gore o tlogetse mmereko, so that ba tlo kgono attacha tšhelete ya gae a ska kgono e ja kaofela ba tlo re ngwano gore a fitle 18 years o batla bokae ba ilo nka ko pension a itotsing akere. So le matheleng ko court le ba botseng gore o tlogetse mmereko akere. Okay, go na le potso ene le batla go ibutsisa ko ga go I think dipotso tse dingata di tlo ya ko advocate, family advocate. Go na le potso e motho na batlo ibutsisa o motho a batlo go tšho gore ne ke ile ko court ya ko kae ha zang ba nthusa. O bolele lebitso ne how o emela o bolele lebitso Lebogang. Okay, ke bone letsogo mo, and then 4 or 5. I'm not going to take more hands. 1, 2, 3, 4, 5, and then kitlanka amang matsoga ke go so tlo bona le ba bang ba presentang. I'm looking at the time for reskanka sebaka se sekgolo ne. Ke bone letsogo ko morago. 1, 2, 3 ne go na letsogo le leng mo 4, 5. Yeah. And then kitlanka amang after.
Thank you, Program Director and Dumelang. My question, it's not a question, it's in support. My name is Cynthia Ramulipo. I'm from the Department of Justice and Correctional Service. I'm the DDG for Human Resource, but on behalf of the Correctional Service. I just needed to add regarding the family advocate that some batshabela ko tronko remand. We will want to find ways within the legislation. Motho resignile, and then I committed the crime saying it's in multiple, which means to end up aliko tronko at maintenance. And then Olodula above 2 years, early remand, waiting for trial, because either on a lady case it's a 60 or it's a 7. Utwite, ubulaile, urepile, wait, all of these things at maintenance. But later, when the program start on care, the tomo kick in. Tomo utlo restore says it regulate all of this maintenance. Now, how are you then as departments together in terms of the district model integration, adding also maintenance as an additional charge? Because baba liko tronko bana le ditšhelete ko ntle dia maintain dia continue mara a di maintain bana he o botsisa re na le bana ba ba kae o tlo botsa re na le 13 o na le 14, how are they maintain a liko tronko mara tšhelete ya gae ya di business ya continue? We just want maybe to find out, because we are sisters department Runali Justice on the side of the offenders inmates and the remandees. the additional charges go wrong go court. He before ba sentenciwa, ba iswa ko remand. Who anyway additional charge as part of enforcement of the law to the people ba le ko tronkong before ba lo seka ba seke lia maintenance or e kgone ba le a strength nyana sa enforcement. I think we will need to work on that as part of enforcement part as in Justice Department. Thank you.
And then, yeah. There was a hand here. Lebogang, yeah.
Thank you, Program Director and the audience. I don't know mine is relevant or what. Advocates, there is this tendency of girls not allowing boys to come and see the child because the boys are not working. And then you will see that this boy is willing and he's trying to maintain the child. But because of not working, the girl is not allowing him to come and see the child. Secondly, Minister, I'm doing a plea. Can't you go, your office can go region by region and hire youth, more youth, and train them so that the maintenance officers are many, so that the maintenance thing can go faster. Thank you. I forgot to tell my name. I'm Refima Mutupi from Amaskral. Thank you.
Thank you. There was a hand. There was a hand there. Okay. 1, 2, 3, 4, 5. Yeah. I have not noted them. I said next round because they'll still want to ask questions later. There are other presentations.
Sanibona nonke,
Yeah.
igama uzodwa wakaMashaba, ngiphuma ekuruleni, ku-Andrew Maphethu. Mina into bengicela usisi cishe wangikhavara kancane ukuthi we need to train amantombazana nabafana ukuthi fanele baziphathe kanjani. Because thina manje siyikhuluma sesiyikhale phezulu ukuthi why banga maintain. Kanti fanele sazi umsusa wayo ukuthi kahle kahle kuze kube kanje kwenzakalani. Because ngingumama nami ngumuntu wesifazane, we've got this tendency yokuthi umntwana ngiyamazi ukuthi okaJohn. However, what I'm going to say is because ngibona uJohn ngathi akamanga kahle bese ngithi umntana kaPeter. So that's the challenge that you're having, because now at the end of the day, that is why they end up saying the mother knows the father of the child. And we must be honest as women. That's why sometimes there's this thing that they call it one night stand. And we must be honest with that. It was a mistake. And with that one night stand, who did you sleep with? Is it a married person or somebody who's got a wife or got a girlfriend, a steady one? We must be very clear on that one. Because I cannot say because of my bitterness and say that person doesn't want to support. So that is why what I'm saying is, what I'm asking and pleading, we must teach the girls from school. By the time you start and decide you want to be active, you must know your story. You must know your story, and you must know what to do the next step.
Okay.
So into engicela ukuthi let's asibateache basasebancane, because ezinye izinto ziqala they started at the age of 15 abazi ukuthi kwenzakalani.
No, we got it. We got the question.
You've got the question.
Unless ufuna ukubuza omunye umbuzo, because we're running out of time.
Yeah, so bengithi nje ngicela nje lo ukuthi ngicela nje assistance kulo ukuthi njabo mama mabakwazi ukuthi baba umama ngempela.
Okay, can we go to the next? I think the next one was here, number 4. Utlabutisa after Nesi wena. There was a hand there. Ne le yena, ne se yena, ne go na le letsogo kwa. Okay, mo fe yona. I thought there was somebody else. And then the other one was right at the end, only those. And then we'll give them an opportunity again.
Okay, Thobela,
Okay.
ke Joyce Hamoloto from Ekurhuleni Tembisa. Ka Sepedi ba re ke la ka leo. Dibuledi tse pedi tse di buletse di nketse mantswe to ya hore we are not allowing bana ba rona ba bona bontate ba rona, but we are allowing them to go to their stepfather. This is the reality. We can't run away from it. Thank you.
There's another hand. There was another hand. Ke mang, ke kopa o emele o na le kwa. Yeah.
Ke a leboga. Lebitso ke Stefina Malapane, ke tswa ke le Hammanskraal. Question ya ka ke gore ana re ka kgona gore o ilwe re isitse bontate ba rena ko maintenanceng taba ya gore ba patele 250 and 350 e fedisiwe. Ra kgopela gore if pape ngwana wa dumela 500 upwards ke yona e re kgopelang, and then a ke kgopele fela ko bo ntateng for site la bo ntate le for site la bo mme. That money a se ya rona ke ya support ya ngwana, a re berekiseng pila gore bo ntate ba kgone continue ka maintenance wa bona ke ba dumetse gore ba patele maintenance. Re khawane le di manicure and pedicures re tlhokomeleng bana.
Thank you.
Thank you.
Thank you. Okay, I will request advocate to respond, and then we'll go to the next session. I'm worried that we are running out of time.
Thank you for all
Lebogang.
those questions. I will go through them quickly because it looks like they are all interrelated. Ne? Mayor Ramolefu, we are busy with IJS. Remember when I said, even though we are not succeeding as well as you would like us to succeed, but below the surface, we are pedaling very, very hard. There is a system which is used in the criminal court environment, Barke IJS. It traces people very quickly, whether they have previous convictions, it can verify their identities and so on and so on. So since about May or June of this year, we have been talking to the IJS team to see how best we can tap into what they already have, which will fast track our track and tracing, because when we presented track and trace in maintenance to our minister, Minister Lamola, he loved it very much. So we started channeling our energy in that to speed up our track and trace. So we are at a very advanced stage of teaming up with IJS, it's Integrated Justice Services. Re rata di acronym re confuse batho. So re tlo khona go verify batho ba di respondent ka pela. Then it will shorten your waiting period whilst re sa batlana le maintenance investigator kwa le ba re tla go kena mo systeming ra ba batla. I'm happy that Meramulifo raised the issue. Once IJS takes off the ground, then we will move much quicker in track and trace. And then I'm not alone, I've got my team here. Please indicate to me if you want to tackle some of the questions. And then otherwise, the speakers that followed thereafter are just affirming what has already been said. And I've already alluded to some of the points. We really need to see how we can up our parenting standards. Parenting arena is not on par. And you know, I like giving my principals for Department of Justice this example. If we don't work hard, remember a child's formative years are not to 6, psychology, not to 6 years. You are shaping how your child is going to see the world for the rest of their lives. Now, ge ngwana a gola ka mo gare ga conflict, a gola ka mo gare ga neglect, a rutiwa gore ntwa is a way of solving problems and so on and so on. You see the result. I don't have to convince you. You see what our society looks like. Then these are things that we should have tackled when our children were not to 6 years of age. I see Miss Peter's hand is up. She's part of my team. My boss. Let's start with my boss. The gentleman sitting at the table is my boss, Mr. Malema.
Tieti, I couldn't see you. We must remove the antenna so that we can see you.
Thank you very much, Dumelang, and like to pass my appreciation to the presence of the minister and the dignitaries, Sanbonani, Dumelang Kaofela. We've worked with Joyce many years ago when we started in the Department of Justice, so it's really a pleasure to continue with the collaboration. I give out just a few things to give you comfort that this struggle. Yesterday I was reading some quotations by Thomas Sankara, and I was very excited to see he says the struggle for liberation cannot be complete without the liberation of women. You see, so that was many years ago when he said this, and that is still true today, that we are on your side. The Department of Justice, the DG has formed the men's forums in the different regions, and part of those men's forums is to allow men together as abobaba, to go to the tavern, slale pants, skulume as a machita wood. But it's not right to maintain abandon. Because you see, there's this thing under the tree dialogues. It's also part of our discussions now. So that, because sometimes magune session a formal. You see, so we want to go to the shibins where they meet. We want to go to the car wash where they meet and use the language that they use, because that's where the wrong things are exchanged. You would, so that we talk to them that they need to do a maintenance. But secondly, I want to say, if you go to the courts, there are numbers there, telephone numbers, cell numbers in particular. I can tell you, yeah, I get there because I get the calls from maintenance complainants almost daily. That cell number, you can ask the person on phone to call you back, because this is the phone name that is paid for by government, right? So when you call, I'll say, okay, let me call you back. I was dealing with some ladies last week, Friday, go box back, and we dealt with the issue. So use those numbers as well when you don't find joy, if you are not happy with what they are telling you. But also, if you're not happy, there is a senior magistrate in every court, right? Every court in a senior magistrate who's in charge. If you feel the officials are critical, insist. It's your right. It's your right. Insist. The senior magistrate. Because sometimes we know, and this happens, we were talking in the Aushoki here about the corruption, about files that disappear on the day of the matter. Right? So the matter must appear Thursday. Everything has been in order. Thursday, suddenly the file is gone. You understand? So part of what we're also asking the magistrates to do is the interim orders, right? Because the law has already provided for them. They do up and down. If he does not come and has been served properly, the court must just issue him with an interim order so that he starts paying. And then that will get into his mind, he must come to court, right? So it's part of, Joy, it's part of the social context training that we will revive, because sometimes the judicial officers may not be sensitive. They could be men and they may not understand the problems that women go through. So there is a program here in magistrates called social context training that teaches them around things about maintenance, the problems that women have, because we've said it's not even enough for men to say, I am paying maintenance. I think somebody said that, and we're saying this as men's forum, that it is not enough to pay maintenance. Your child ufuna utando as well, right? Batla lerato as well. It's not enough. This is not a financial transaction. You understand? To say, I'm patali 1,000, so what else? And that 1,000 is not enough, because who pays when the child is sick and the woman is unable to sleep at night, worried about this child? There's no money for that. You understand? So we're saying, we encourage them. Go take your child to school, walk your child to school, so that your child is protected. Have a bond, nomtwan. But as I said, this is a struggle for all of us, and you can count on us within the Department of Justice, with the colleagues here. And there are also regional heads, Joyce, online for the whole country. So they are listening so that they can also assist us in the different regions to actually resolve these issues. Thank you.
Thank you. And thank you for your support. He called all the provinces participate, and I hope they were able to participate. Those that couldn't join, they must go on YouTube so that they can join. And those who are on YouTube, if you want to ask questions, please send your questions to Ranji, RANJI.Reddy, which is REDDY at women.gov.za. Send your questions to her. She will give them to me. I know that virtually there are questions. Some of them are very long, so I've requested them to be summarized. So the next round, we will do the questions that were on the chat, and those, if questions have been sent on email. Yes, from Justice also, you wanted to add? Yes.
Greetings to the Minister, the Program Director, and all the esteemed guests and everyone who is here. I wanted to speak over what Swesi Zodwa, Mashaba, as well as Stefina Malapani spoken about. Osi Zodwa obuletika, what we call responsible parenting. And responsible parenting means that whenever you enter into a relationship and subsequently there's a child, you have concluded, or two forms of relationship have ensued. The first one is the romantic one, where there are no guarantees. Angakulahla umuntu because akazalanga nawe. He can drop you because umuntu lala aphenduka. So there are no guarantees there. Therefore, you have no right to be bitter and start focusing on your issues that have got nothing to do with this little one that did not ask to be born. Please let us take care of our mental health. Let us go and see social workers, therapists, and other mental health specialists so that we deal with these issues that are burdening us, that we are still not have mourned the loss of the relationship. Now, when it comes to the parenting one, please know that it is a lifetime one. It is permanent. It does not end unless you die or the child dies, but we don't want our children to die. So please know that you are responsible for that child until they become an adult. So that responsibility, you go with it together with this second person. So let us not cause things that are going to be getting our children in trouble in the future, because it is going to make them prone to join the ranks of the criminals at an early age, simply because abatoluthando endlini. Then we are giving them parents on the streets who are going to be the bosses, and etc. Now, coming to the question here, Stefina, I'm one of the trainers, study maintenance officers and maintenance investigators. And during the training in the 6 provinces that we have already managed to go to, despite the severe capacity constraints, I always say that maintenance officers have a duty they have a duty to deduct certain expenses, study defaulters. That we have trained, we told them that in terms of Section 8 of the Maintenance Act, call upon the financial proofs that the defaulter and share them with the complainant. So mama, una le right ya gore you view them. And when you see that, Papa O, una le di life policies J5, o swipe ko Santing, o patela BMW X5, even o patela di bond tse tharo. The maintenance officer has a duty to deduct those, to get them to cancel that DSTV premium, ya 950, ammotse gore a yo dia ya 200 rand, so that we can take that amount and apportion it to the maintenance ya ngwana. You can demand that. It is your right. No one should be having 5 lifetime policies because we know the insurance law does not allow that. So if Moto on their statement to appear are 5 policies, get them to be taken down so that that money can be taken to the maintenance so that we don't have the 200 rand thing. So we have started with that build up, and hopefully we can filter it into the legislation so that it can be regulated. Thank you very much.
Thank you, thank you. Correctional services, I think the Department of Justice has heard that, and now when they trace how what we uko jele, Department of Justice will also trace is this person who's arrested, has he just resigned from work, does he have pensions and all those. I think between the 2 departments, and fortunately the 2 departments are under the same minister, you need to sit and talk and look at how do you work together. How does correctional services assist justice, for justice to be able to access the data or the records of the people that are in the presence or maintenance. Le sa tlo kgona go botsisa dipotso, ke kopa gore now ke ye ko the next session ya program ya rona. We have 3 minister le advocate tswetswe, forgive me, ke lisa kwa ke tlo kopa le boele ko di sitting, and then now ke tlo kopa advocate Anthea Platt SC, Miss Lily Tefo. I think Miss Lalita Chetty has joined virtual. Kitlo kopa le dule mo so that Rito presenter. Advocate Anthea Platt Utuako Basadi Bamlao is an organization. She's already an advocate, but the advocate only kikupa me one share about 3 ml. Please. Kikupa IML, she's one of the most attorneys, most senior attorneys, most South Africa, most senior female attorneys, Coco South Africa, and she is the chairperson, the Legal Practice Council. La bona ntwele ya hore batho ba use di attorney or attorney o sa pataling maintenance or attorney o shapang musadi, bona batla mo di registera o ngwalla ko bona kwa batla mo di registera. Go na le di attorneys tse tsamang di lo representa bana ba lona mare di etse bokurukuru, ke ena ba representang ba tlile ba le babedi, ke bona ba cherang basadi ba molao, ke me Poti Lepu, Matkin Matolo Lepu. Just wave. Basamaya Balibabedi. They are the most senior. And then South African Women Lawyers Association. Leona, Keva Sadi Balinkomula, by Purison Batokopana, Horifela, we come up with programs that are empowering, but also will implement programs that are empowering Basadi. So the programs for to uplift the community without really wanting money. And then Miss Lalita Chetty, ki magistrata, Liena Uko, the South African chapter of the International Association of Women Judges. Ngiyaxolisa ngitsheliwe ukuthi the Nguni speaking, bati ngiyaba exclude ngoba ngikhuluma isiSuthu. Sengiba introduceile labantu abazokhuluma ukuthi baphuma emthethweni abafazi abasemthethweni, but also kune magistrate representer association yabafazi abangamajaji nama-magistrate. So nabo bazokhuluma kunezinto abazenzayo ezizonceda, but also ngoba bona basebenza ngomthetho bazokwazi ukuthi basitshele ukuthi i-maintenance abuse isho ukuthini nokuthi fanele wenzeni ukuthi ukwazi ukuthi uthole uncedo. And qala u-advocate lo wase-justice bekakhuluma nje ukuthi bayalinga e-justice ukuthi basolve ama-problems wasema-court, kodwa ama-applications maningi ngesinye isikhathi uthola kuna 200 applications, 200,000 bakwazi nje ukuthi basolve 34,000 ngoba nabo abanabantu, hayi ukuthi abafuni ukusolva wonke kodwa because niyazi ukuthi i-country yethu inama-financial problems, so ba-end up abakwazi ukuthi badile nge-34,000. Enye into ayikhuluma ukuthi ezinye izinto between umama nobaba womntwana bangakwazi ukuthi bakhulume basolve indaba kunokuthi balwe, bakwazi ukuthi i-maintenance ibhadalwe ngoba i-maintenance doesn't have to be paid e-court. I-maintenance angeze azobhadala umuntu nivumelane nobabili abhadale every day, kodwa because of lento yokulwa nithola ukuthi manje fanele niye court ithatha isikhathi bese akwazi nokuthi athi angisebenzi ngoba awukwazi ukuprove ukuthi unemali, kanti if benikhulume nazwana bekazoyikhipha imali ngoba imali yona unayo. Kodwa enye into esihluphayo yileyo ukuthi uthola lo muntu lo une-double story unama-taxi uwabhalise ngosisi wakhe. So nathi ngesinye isikhathi siyikhosi ye-problem ukuthi sinceda abobaba ukuthi bafihle ama-assets banga-maintaini abantwana babo. So i-community, sonke esi-community si-responsible to ensure ukuthi abantwana bayawondlwa, angithi maintenance isondlo, angithi. So isondlo i-responsibility yethu sonke. So yinto nje ubuningi bethu besikhuluma ngayo la. Ngiyabonga. I would like to call Advocate Black.
Good morning, Program Director, Minister, distinguished guests, and everybody here today. Good morning to you all. I'm privileged to be part of such an auspicious event and on such an important topic like child maintenance and how we can enforce payments. But before I deal with the challenges, let me just speak to you about what Basari Bamalau is and why are we present at this event. Now, Basari Bamalau is a woman empowerment sister circle, which focuses on women, professional women in the legal industry. We have attorneys, advocates, psychologists, students, educators, all of us part of Basari Bamalau. So you don't need to be a legal professional in order to be part of Basari Bamalau. We also have an education and training services company, which strives to empower individuals and communities through delivery of bespoke and professional learning interventions. As a group, we aim to ensure credibility and authenticity in our approach, methodology, techniques applied to the professional development, teaching and learning. So if you need us to develop a course or a workshop, we are able to do so instantly. You can ask us to help with training, and we will provide the necessary materials and the necessary trainers to go and do so in every community, wherever you want us to go. So that is what Basari Bamalau aims to do. We aim to empower women and empower her story. And because we're in the industry of empowering women, we have developed a course, actually 2 courses, called Financial Abuse, Domestic Violence, and then also Financial Abuse Maintenance, in which we provide, whether it's social workers, maintenance officers, women in the communities, the necessary education to equip them when they go to maintenance offices, and to understand what financial abuse is. The latest statistics show that 99% of all domestic abusers use money to control and maintain power over victims, which ultimately impacts the children. So what can we do? I've looked at the Act, The Act covers women. It provides sufficient legal structure for maintenance to be obtained, as well in the Domestic Violence Act and in the Maintenance Act. I think the Domestic Violence Act, not everybody knows about, but it provides quicker relief. If you need relief almost immediately, you can go through the Domestic Violence Act first before you can go to the Maintenance Act. So what can we do to alleviate this financial abuse problem that affects child maintenance? Well, the
Okay. This is now Dinta.
Extend our sincere gratitude for having invited us to this event. It is really such a great pleasure indeed, Sis Joyce, an honor for Saula to be part of the beginning of a remarkable initiative by DWYPA. We thus hope that Saula's participation herein will be of a valuable nature and will go beyond this event in order to ensure that women's unequal and social position is addressed accordingly. For the sake of those who may not know what Saula is all about, I'm just going to briefly explain what Saula is. Saula, like Sis Jess has already explained, it's a Women's Lawyers Association, which was established in 2006 by the then Minister of Justice, that is Bridget Mabandla. And the purpose of this organization is to capacitate and improve the lives of its members and other women in the profession, as well as women within the society. So in essence, it's actually here to empower and advance women lawyers, and women at large. So Saula is, like Sis Joyce has indicated, that Saula is present in all the provinces of South Africa. And how it does, it engages with the broader society through our outreach programs, like the current one, the 16 days of activism, and many more. And this year's theme in respect of the 16 days of activism is we are taking the service to the people. We just want to go to the ground roots. So we are saying the government departments should be accountable to the members of the public. So Saula is not only for women, it's also having a provision for our male counterparts or male membership, in that they are allowed to be friends of Saula when they want to join. And jumping quickly to the business of the day, we're talking about the many challenges that are facing the country, that face the challenges faced by the country's maintenance system. The minister, when she started talking, she took my words, which is the question that I want to throw to this house, that it takes two to bring a baby in this world, but it will take one to ensure that the baby get to be raised. Why? Why is that? We need to ask ourselves those questions. If we've got men in here, please ask yourselves those questions. Why does it take one to raise a child when it takes two to bring the child to this world? The law, Sis Joyce has indicated, the law is very clear. The duty to support the child lies with both the mother and the father. So, I also like the point made by the DG earlier on, when she said, we are addressing the bigger challenge here, the challenge of 99%. We're dealing with 99%. 99% is the women, and the 1% is men. Those who would say that we are also not getting maintenance, or we are struggling, or we are whatever. So in terms of section 18.2 of the Children's Act, it provides that both parents have the responsibility to care for, maintain contact with, and contribute to the maintenance of the children. So many people believe that that legal issues in respect of child maintenance are simple as compared to other legal matters. In theory, it could be so. However, in practice, child maintenance cases are very complex because, listen to this one, it now appears to be the best interest of the child versus emotions of the parents, which are at play. So the challenge comes in when the court has to make a decision because it looks at what is fair and proven. There's a typical example of a magistrate's decision that was taken in Port Elizabeth, which was taken on appeal in the Eastern Cape Division, Grahamstown, under the case 127 of 2018. In this case, the appellant, that is the mother, and had claimed an amount of 5,500 per month for the child's maintenance. At the end of the inquiry, the maintenance officer submitted that an award of 1,000 to 1,200 would be competent. However, the respondent, that is the father, did not make a full disclosure of his financial circumstances. Therefore, the magistrate directed him to provide various items in respect of his financial circumstances. So the matter had to be postponed. On the day of the court, the very father failed to provide the requested information. Then the magistrate had to hand down the judgment for the father to pay the maintenance of 1,000. So the ground of appeal, amongst others, was that there was no proper investigation by the maintenance officer into the party's financial affairs. Now, these are the typical challenges that the litigants, particularly women, meet up with, where maintenance court will make a decision that is based on the evidence at hand, because they will say that we do not have evidence. They are expecting much from the woman. Where is that poor woman going to get the information? The poor woman has to prove the case, and the man will come and just stand and say, this is how what I'm earning. So the mother would come and claim a specific amount of money, which she considers fair to sustain her child, as she is of the view, and she may be knowing the financial status of the father. But the father would say he cannot afford. But the unfortunate part of this is that she does not have, the problem is that the woman would not have the concrete evidence as it has been indicated on that case law. He does not have the concrete evidence to confirm that particular amount of claim. So on the other hand, the father, what does he do? He refuses to disclose his financial position. So that's where the bias come into play. The bias come into play. Now the question is, how is the best interest of the child taken care of in this case? And truth be told, who feels the brunt? The woman. So in the conclusion one can draw from this case is that the courts would be understaffed, hence this hasty decision. They take this kind of decision, maybe they are understaffed, or maybe they just want to move the matters in order to get to finish the case, the role. And also it could also be the lack of training. So the minister also here, he emphasized, which I liked, he emphasized that women and children, he emphasized the socioeconomic vulnerability encountered by women and children. And that should be addressed. So in this case, by ensuring that the enforcement of the maintenance order without any delay. So they need to be addressed without any delay. So the Maintenance Act 99 of 1998 is in full compliance with the provisions of the United Nations Conventions on the Rights of the Child. But then the challenge is that it has not made any impact on ensuring that the parents take the responsibility of maintaining their children seriously. We notice this when we are seeing the increased number of children who are registered for government child support. And we also see some fathers who are blatantly refusing to pay maintenance. Some are doing that purely to spite the mothers, and some are just irresponsible. Statistics also show that there's a high rate of child maintenance defaulters. It is also such a challenge to enforce the executed somebody did indicate that it's such a challenge to enforce the executed orders of garnishee because the assets cannot be found because they are concealed and others choose to resign and disappear from their workplaces. The other challenge is that the mothers are also expected to know the addresses of the defaulters. I find this to be an unreasonable requirement. Yes, the tracking system of phones, CIPC, I'm directing this also to the Department of Justice. CIPC may be helpful, but for who? Because most people are self-employed, some are an informal business, some do not register their cell numbers, others do not even have the bank accounts, the taxi drivers, the mechanics, and the builders, and. Furthermore, both parents are expected to contribute equally. However, in practice, it's only the financial contribution that is considered. The emotional contribution by the custodian parent is often neglected. Now, we need to see as to how can we address these challenges. We've got the challenges. Now, how are we going to address the challenges? You know, the DG, the chief family advocate, you know, have articulated the point that they really want to see a change. They are really working very hard to ensure that you know, change happens. As in terms of the constitution, there is still an emphasis on the best interest of the child, which is of paramount importance. However, the problem is we've got the poor procedural mechanism for enforcement, which has already become, it's becoming more common. As such, it makes it very hard for the role players to ensure that the rights of the child are upheld. The family advocate has confirmed that there's an implementation of the maintenance. No, she says the implementation of Maintenance Act has failed or is failing decimally, which is so true. So now, in the best interest of the child, these flaws, how can we avert these flaws? We avert them by addressing the issues amongst others. Number one, we've got the maintenance matters should be accorded the same level of importance as other legal matters. Section 10 inquiry should be reconsidered. The fact that it allows postponement while the child is left hungry leaves a lot to be desired. So there must be interim payments in the process. Once they start implementing that, they must also put the thing of the interim payments. The fact that the mother should obtain the bank statement at her costs in order to prove the default is unfair. There should be an efficient tracking system in the department to keep track of the payments made. The costs of bringing the defaulter to the book incurred by the mother should also be taken into consideration when doing the calculations. We're talking of traveling costs, we're talking of phones, we're talking of all those expenses that the mother is incurring. And also, one other important thing is the prescription of claims that should be dealt into, because here we are dealing with the child's right and not the parent's interest. So I also liked the fact that you talked about the intake service training to address the backlog, chief advocate. And we are saying as SAULA, we are available. If there is any need, you would need our assistance, we are there for services, and we are there to serve the community. And then another few last things that I also want to, to suggest are that we are living in the world is changing. Digitalization and online platform have become a new normal within the society. So automation of the systems could be the smart way of addressing the bottlenecks in enforcing the orders. The automation systems have proven to be working in our courts, and it appears to be moving fluently. So this should also go down to the maintenance courts and all these other courts. The lack of uniformity within the courts. Example, some ensure interim order while awaiting final adjudication of the matter. Others do not even need to be looked at. Blacklisting is meant to assist, but would seem it can compromise the defaulter in accessing funds to pay. The court systems must be incorruptible. The fact that matters are heard in chambers is a standalone issue and must not be read with courts being incorruptible. Another important, one last thing is that intensive training for the maintenance officers and officials should be given a priority. You know, the DGF indicated that the reception at the maintenance court is very hostile. It's so true. We are even as afraid of those officials at court as the legal officials. You know, I remember there was another time I was treated so badly to an extent that I had to send a WhatsApp to the deputy minister. Fortunate for us, we've got the deputy minister who is, dedicated to his work, and he responded immediately. Imagine if they are so hostile to us as professionals, what more about the people who are just, an ordinary man on the street? So they really need a proper training to understand Batopili and understand how to deal with people. And in conclusion, indeed, children need a special protection as they are also there, like their mothers, the most vulnerable in the society. Thus, the progression of this initiative, DG, will ensure that the right of a child in South Africa is protected accordingly, as it will facilitate and accelerate the crafting and enhancement of the existing maintenance dispensation. Thank you so much.
Milelo. Kilaruna, what you said, Elam. I don't want to repeat what you said because we're going to lose the magistrate. So I would like to call Miss Lalita Chetty. She's going to court. So she's a member of the South African chapter on the International Association of Women Judges. So always magistrate, judges, advocates, they are not all the same. Who are out there to ensure that the rights of women are protected, and they will go all the way to make sure that they promote the rights of women. You know, in other countries, they'll tell you that judges can't be involved in certain things, but women judges and women magistrates and males, they're males who are members of the South African chapter of the International Association of Women Judges. They decided independence and judiciary can stand in our way to protect or to promote the rights of women. So I will request Ms. Lalita Chetty to present. She's presenting virtually, and I will complain about what other magistrates are doing after her presentation to ensure that we don't miss her. Ms. Lalita Chetty. She can connect now. Or maybe she joined after. I indicated earlier on that we have a problem with the 100, but when she's back, I think she'll tell us so that she can be able to join. But I want to raise some of the issues. Since she's not here, I want to say some of the issues that women are complaining about. Not just the clerks of the court, it's also the magistrates, the prosecutors. We have the clerks. You have the maintenance officers, which are prosecutors. Unfortunately, I couldn't get NPA people because they said they were going to a strategic workshop. I wanted them also to come and respond to the issues that women are raising, the concerns that women have in terms of when they go and apply for maintenance. But having said that, I want to make it very clear. There are people that we call stellar stars. You go to the court, you go out from there, you are so happy that this person, from the clerk to the maintenance officer to the magistrate, you realize that, wow, are there people like this? And then to some courts, you think, how is this person employed in our courts? When I was still in justice, I went to a certain magistrate court in the Eastern Cape. I think it was PE. And from there, we were with the regional head of the province. I told the regional head, remove this person from the maintenance court, take them to the criminal court. The criminal court, you treat somebody badly, they tell you, I will find you. When I come back, I will get you and I'll deal with you. Women can't do that. So they're afraid of those. So people who are in the maintenance court who are not doing their work, they need to be sent to the maintenance court. Some of the issues that women are raising that are challenges because of the magistrates are that some of the magistrates do not take into consideration the history. This woman says, this man took the child to a school, a Model C school. This person was paying for the child, was paying for everything. Now that we have fought, he's no longer paying. Then when they go to court, when this person says, I can't pay, the magistrate says, remove your child and take her to a township school. And this person can afford. So it's like, why do you want your child to go to a Model C school? Take the child to the township school. And we know, I'm not saying anything bad about the township school, but we know that the level of preparing the children differs. Some of them are saying they are just treated badly. When you appear before the magistrate and you look like you're a professional and you can afford, you are in danger of not getting what you want. There is this case I know because I dealt with. Unfortunately, I left the bar before I took it further. There's something called Section 6 application. Abantu aba-apply maintenance bias. Section 6, the initial maintenance application. Then, mawufika lapho, if lo muntu akafuna ukubhadala maintenance, but he come back for Section 10 application. So the first appearance in court, the father, they were in Cape Town. The father was there, but because they couldn't agree on the amount, the matter was postponed for Section 10 application. And this is what happens most of the time. The father will come, the next time they don't come, they send an attorney. That's why you are saying attorneys must be removed. Attorneys must be involved only when now there's a criminal matter against this person. Yes, they have a right to be represented, but where people are talking about maintenance of the child, attorneys must be removed. So when they come back for Section 10 application, the father doesn't come, the attorney pitches up. When he pitches up, the magistrate in this case asked, have you been given authority to accept the order that will come from this court? The attorney said yes. And then there were 3 children, it was 2,000 each. The order was 6,000. After a year, he paid. After that, he paid. After a year, he starts defaulting. He even moved from Cape Town and came to Gauteng. The mother moved from Cape Town and followed him because she was saying, I do not want my children to grow up without access to their father. So they need to access their father. She came to Gauteng and he was paying, though he was no longer paying all that money. At some point, he was in default for about 60,000. She went to the court to apply for enforcement. The father came with the attorney then said to the court, there's no power of attorney in the file. The magistrate, the father is not saying the child is not my child. The father is just saying there's no power of attorney. The magistrate cancelled the maintenance order ab initio so that the order was, she's holding her head. It's true. I have that case. He cancelled, he declared the maintenance invalid ab initio. This woman says, the way I was so angry, I couldn't even apply for maintenance on that day. I cried and went home. So after 2 years, she comes back. I was dealing with a matter pro bono. And at that time, the guy doesn't want to pay. The magistrate wants to offer 500 per child from 2,000 to 5. He can afford. The last time She called me even when I'm no longer at the court. She said to me, now he's applying for the maintenance to be reduced even further because of COVID-19. He's working alternate hours. So the next thing also what he will do, he'll come and say, I'm unemployed, I can't pay maintenance. This person has been working, he has a house, he's got a car, he's got all those things. How, Mr. Malema, now this is the question to you. How is the Department of Justice working, the Department of Justice and Constitutional Development working with the SAJE, South African Judicial Education Institution, to ensure that magistrates are trained on the Maintenance Act so that they understand it? How do you cancel a maintenance order and yet the father is not disputing the fact that the child is his? There are many matters that I would like to speak to. However, I would like to call, let me check again. Ms. Lalita Chetty, are you on the 12:30? Okay, okay. Can I ask Justice to come and respond to some of the questions? There were questions on virtual, on the chat, and there were questions on the YouTube. They emailed the questions. So I'll request the Department of Justice to respond to those questions. You can come here.
Greetings again to the Minister, the Program Director, and esteemed guests, as well as everyone who is present today. Ke kgopetse hore ke lebelele the following questions. The first one ke ya ngwana wa mengwaga e mebedi, whose father, who I'm going to term for a lack of better word, gore ke an ATM father. Fathers who just only want to throw money, hoping that they have extinguished their responsibilities with regard to the child. Earlier on, I spoke about responsible parenting, and responsible parenting further means that you have a duty to maintain contact and a relationship and to ensure that that relationship is preserved up until the child is an adult. And I think we seem to be missing the point that for as long as I'm paying maintenance, therefore I have no responsibility over the child. Now, the father is now coming back wanting to throw or lay blame at mom to say that, Mom, I now want to see the child for 4 weeks during this December holidays. The child is only 2 years old. And now mom is having concerns that the child is only 2 years old, then how does this child then get unplugged from their place where they are used to and they are comfortable to go for 4 weeks away to be with a father who's just only paying maintenance and not having any form of contact with the child. Now, responding to that, I would say that at all material times, at all times, we need to be cognizant of the best interest of the child. The Chief Family Advocate mentioned earlier on that the best interests of the child are of paramount importance in every matter concerning the child, meaning that we are not going to look at either papa or mama. We need to look at this child. Now, in the language of family law, we speak about the developmental needs and the developmental stages of a child. Now, a 2-year-old child, I've got a 1 year, 6 months old child that I know very well that she gets tired very, very quickly. And in order for her to have contact with the other parent, it needs to be frequent, it needs to be phased in, especially if that particular child has never had any form of contact with the other parent. So in this case, there is a solution. Mama, because of you have been summoned to the Children's Court for custody purposes, please request for an investigation by the Office of the Family Advocate. Now that office is a multidisciplinary institution consisting of family advocates who are lawyers by profession and the family counselors who are social workers or what we call the socio-psychological professionals. Now they will have to conduct an investigation into the welfare of the child because this child has not met papa at all. And because of that, we cannot shock the child's system. We need to face in the contact so that one can be comfortable with Papa before they can have a prolonged relationship. So this is not to say that we want to spite Papa for only paying maintenance, but we need to look at this child because we don't want the child to be anxious. We don't want the child to be scared. We don't want the child to be wetting the bed. We don't want the child to be scared all the time simply because he's going to be meeting this stranger. So this is not to spite Papa, but to ensure that we preserve the best interest of the child. So please get the investigation by the family advocate so that we get then recommendations as to how we are going to deal with this situation so as to protect this little person in our midst. The second other issue relates to maintenance. Someone asked, what about the issue of alienation? You pay, but you don't have access to the child and the courts aren't assisting with that. Remember that maintenance in South Africa is regulated by the Maintenance Act. And I don't want to be academic, but ke batla go ba practical. When I'm being practical, please let's note that the maintenance courts are the creatures of statute, meaning that they were created in terms of the Maintenance Act of 1998. And it is very clear that every maintenance case, unless you make a direct application to the High Court, it needs to be dealt with for the Maintenance Court. And I think the DG spoke about Section 6 inquiries. Ne? Section 6 inquiries are conducted by the maintenance officers, and no party within the maintenance process can ever see the magistrate unless the Section 6 inquiry has been concluded. Ne? Meaning that you both get the chance to sit down with the maintenance officer to address the issues affecting the caregiving of the child. And in such proceedings, we cannot deal with issues affecting the contact of the child, but those must be dealt with at the Children's Court. So please, let's first address the issues of maintenance of the child and then go and lodge an application with the Children's Court for the purposes of dealing with the contact of the child. And remember, please remember everyone that contact is the right of the child first. The right of the child first. We don't want to be having a child that is going to be recovering from their childhood simply because they never had any relationship with the other parent. I'm one of the people that loathe or that hates the two programs on TV, Utatako and Khumbule Khaya. I hate them with passion because they are the product of the social ills in the society. Have you seen who are the people who are approaching Khumbule Khaya? Most of them are very old. What are they dealing with? They're dealing with fractured sense of belonging. Some of them will come to you and tell you that I am not able to get a job simply because I've been told that I need to know where I come from, Imvela Piam. Those stories are very real. So you, the one who is denying contact, tomorrow you will die. What's going to happen to your child? Do you want your child going up and down, going to look for the people that they've never met? These things are real. We are Africans. Some other people are from those clans where in order for a child to be okay, Basanzore, Baba Pachel. I remember recently on Babgeld, we're talking about somebody who had concealed paternity ngwana, told the husband, meanwhile, ngwana was somebody else. And when that child turned 9 years old, he was busy losing vision. And she went behind everybody's back to go and speak to the real father. And the real father said, you know what? I can attest to her, this child is mine. Because I know in our families, when we reach this particular age, we get to suffer that particular problem. So it is very important to her, so that where do they belong? So please do not do that. We do not know what tomorrow holds. Like COVID-19, it does not choose. Unlike HIV/AIDS, we knew that it was attacking a certain group. But with COVID-19, all of us, we are going. So please do not impart such kind of trauma to your children. Let them know their families. You know, people laugh at me when I say to them that if you are a single parent, please enlarge the father of your child's photo in their bedroom, enlarge it. Recently, I also had a talk with one of a very esteemed person who has done very well in their lives. That said to me that, you know what, Josephine, I agree with you that, you know, we need not take our own traumas and spill them to our children. And then he said, I met my father when I was only 35. And he said, during my childhood, I was bullied a lot because I've got a big head. But the first time I saw my father, I knew that at least somebody looks like me. At least I'm not an alien. At least I belong. There's a group of people who have big heads. And he said, even my uncles, all of them, they had heads that were shaped like me. And he said, that made me whole. And now I'm starting to pick up the pieces of my life because I know I belong somewhere. So let us not alienate our children. Let us ensure that they have that contact with their parents. The other one was about those the women who are abusing the system, who are going out opening multiple cases at the maintenance court. We spoke about severe capacity constraints, but please note that we have a system called ICMS, Integrated Case Management System, where we use the ID numbers of the people who are applying for maintenance. So we will verify that, and then as soon as we catch you, you will be taken in for fraud. So you don't want to be sitting in jail simply because you tried to go and do piki Mabelani and say Josephine is the father, this other one and that other one, and go and apply for maintenance order. Do not. ICMS is alive despite the electronic challenges that we're experiencing in the department. It is there. We will get hold of you. Don't do it, stay away. Ne? The last one was about the protection that we afford parties in the courts where they get abused by their partners. Somebody spoke about the Domestic Violence Act. Ne? Please get protection. No one has a right to verbally abuse other people or to intimidate them. Ne? Please inform us and let us assist you. Thank you very much.
There are other questions, but I like this one. The advocates also must respond to that. Kifilwe Bopape, how do we define single parents in South Africa? Because there are women who claim to be single parents even when they have the support of the father who lives in a different area or home. Are they single parents? The father is there. Maybe let's say he's married, but he's the father of the child and he supports the child. Is it a single parent? Okay, Kifilwe, the response is they say, no, it's not a single parent. Maybe what she's trying to say is that she is looking after the child alone when the father is somewhere else, maybe with another wife or whatever. But I think it's a catchy question. What does it mean to be a single parent? Also, the question is, this one is for justice, but I know that the courts had already made a decision on that one. In cases where the family of the father, even if the father is not responsible enough, welcomes the child and are willing to support the child, but the mother rejects the offer, how do we proceed? A family advocate will respond to that one. The father is not responsible. The grandparents are very responsible and they want to support the child, but the mother refuses. How do they deal with that? But the third one says, does the Department of Social Development or the Department of Justice have statistics on how many women make direct payment claims on the families of the parents, especially if the father is unemployed and the family is well off? I know that Bishop Tutu, you remember there was a case of Bishop Tutu where the son didn't pay maintenance and the magistrate issued an order against Bishop Tutu. So in terms of payment of maintenance enforcement by the court, I think they can enforce against the grandparents. But where the grandparents want to pay and the mother refuses, I'm not sure. Yes, where's that mic? Where's the mic? Lebogang? The mic there.
Maybe let's tackle that one quickly. You'll recall in my presentation, I mentioned that we are very slow in migrating to understanding that children are bearers of rights within their own right. If you analyze South African legislation currently, the legislation that is applicable, children are no longer the subject of parental authority. They are bearers of their own rights. So mommy did not know that the right to be maintained by members of
The
Davy's
family.
extended family is not her right. And in law, you cannot alienate a right that does not belong to you. It is the child's right. Another slow pace that we should try and pick up speed on is Section 10 of the Children's Act, which gives extreme powers to the voice of any child that is able to express a wish in a matter that affects them. We should be hearing the children. If the children says, I want my extended family, it doesn't matter whether mommy likes them or doesn't like them. The child is exercising their own right. We must work around all those hurdles and let the child have a relationship with members of their extended family.
Okay, thank you. Uthi advocate wama families. Uthi abantwana bane right yabo. Ukuthi maintain ubabakhe or ama relatives kababakhe right yalo mntwana. Ngeke uthi wena ngoba ubaba manje akasekho impilweni yakho uthi umntana akana right yokumaintainwa ifamily yakhe. Umntwana une right. Aksi right yakho umama kasipedi batho ba re ke modidi o matepe modidi o matepe for yourself iseng modidi o matepe for ngwana o na le right ya o maintainiwa ke ba gabo akere ke ntho na icho so go tsho gore batswadi ba tshwantse maybe the first thing e tshwantse ba etse go ya go batswadi ba ngwanyano mme wa ngwana gore ba re ke ngwana wa rona ra mo accepta ra mo dumela re batlo patala maintenance let the family address that ke nagana gore families can be able to address that but if gwapala then that means that's where the children's court now it's not the maintenance court I think that would be the children's court that would address that because ha claim maintenance marbare re batla go tlhokomela ngwana wa rona na le right ya go bana le ngwana wa rona ke batla go acknowledge Kgosigadi Digale ke a tseba gore o re joinile virtually Kgosigadi the first provincial a webinar re tlo banang le yona together with justice re tlotla ko ga gago ko Mankweng re utlwile gore o wa participator and o re o batla re tle ko ga gago re tlotla rona le Department of Justice by committee le di lawyer le batho kaofela ba leng mo re tla re tlo addressa issues tsa maintenance ko ga gago ke sile pampiri ena leng libitso la magistrate o tlo re joinang I think pampiri ya teng Miss Chetna Singh, have you joined? Hi, how are you?
Thank you. Good afternoon to all our participants.
Afternoon, and thank you for joining us. Let me not waste the time so that you may be able to go back to court. Let me give you an opportunity to speak to us. I'm sure you've heard me complaining about the magistrates and the judges. When I started, I indicated that I knew judges who were not paying maintenance. And my biggest challenge that I have with the judges is the fact that judges can't be summoned to the maintenance court. And I've challenged it from long ago. I've challenged even the chief justices that they appear before the magistrate as the father, not as the judge. So we have women who are complaining about the justice system, but also we have magistrates and judges who don't pay maintenance. Maybe you'll enlighten us. Thank you very much. The floor is yours.
Thank you, Chair. Thank you to all the participants for joining. I have been roped in at the last minute to conduct the proceedings on maintenance from a judiciary perspective. Just a little bit about myself. I am an additional magistrate practicing at the Evander Magistrates Court in Mpumalanga. I've been here for many years. Before that, I've been in Pietermaritzburg. I am going to tell you a little bit about the Maintenance Act. Chair, I'm not sure whether I'm at liberty to discuss the issue regarding judicial officers and their duties to pay maintenance. However, I do take the point that insofar as the Maintenance Act is concerned, read together with the provisions of Section 28, subsection 2 of the Constitution, in matters concerning the child's interests are of paramount importance. So that might be an interesting point to consider in an argument that may be made to the higher authorities for why this ought to be amended and why judicial officers should, as ordinary folk in society, subject themselves to such maintenance proceedings. Be that as it may, I'm going to talk to you about the Maintenance Amendment Act. I can, if Lebogang allows me, to share my screen. If you bear with me, tell me, can you see my screen? Are you able to see my screen? Yes, no? Can I get an indication if you're able to see my screen, Chair?
Yes, we can.
Yes, we can.
All right, great. I just want to start with a few statistics. If we move on to slide number 2 here. All right. These are your statistics, ladies and gentlemen. 25,326 divorce orders were granted in 2016. Obviously, we know that the numbers are rising, but what is of more interest must be the 55% of divorces which involve children under the age of 18 years. And as I've indicated right at the onset, where matters concerning the child are of paramount importance, achieve a sense of constitutional importance, which means that this is an issue, or rather the Maintenance Act is an area which needs constant evolving according to the rights of children, which, as I have heard someone indicate before this, children have rights, and where they can be necessitated and facilitated in terms of the Maintenance Act, this should be an issue which is developed further. Right, be that as it may, I want to tell you about the 1998 Maintenance Act. So the Maintenance Act of 1998 was a rather interesting piece of legislation. Firstly, one must remember that we had entered a constitutional period and the act itself was overhauled largely, and it's really been something that is worthy of a global platform. So basically, the courts then from 1998 have made maintenance orders in the absence of fathers who evade service, in the absence of fathers who refuse to appear in court. And what is very interesting now, and as far as your Amendment Act is concerned, is your emoluments attachment order. Your emoluments attachment order is included in your original maintenance order. So in other words, the first time you appear at a maintenance inquiry, or even if you've got an order granted by consent in terms of section 17 of the Act, and if the father or anyone who's legally obliged to support the child does not maintain that obligation as per the court order, the courts grant what we call a normative court order, meaning that we take the application and simply serve it upon the employer of the defaulter, and the employer then garnishes the salary every month from the employer's account and sends it off to the bank account of the person in whose favor the maintenance order has been granted. Obviously, this is enormously beneficial because one does not have to wait until the father defaults on his payments. In other words, you can get this order done by consent. And a lot of parties agree that the order once made must be done through a garnishee. So people find this very convenient and very effective. Personally, in this court, we do a lot of them by consent. And like I said to you, it's a matter of convenience. What about those fathers that owe a lot of money, refuse to pay it for years and years and years, and rack up huge bills. We've had a number of case law that has dealt with this. There's the recent case of Bernsey, a 2020 case, in which the father owed a huge amount of money and criminal action was imposed upon him. I'm not going to touch on the criminal aspects for now. You can look at that case in your own time, or you can email me, and I'll give you my email address at the end, and I'm happy to send it to you. What I'm interested in is the execution against property. All right. The father doesn't pay. There's no money in the account to pay, but he does have a house. He does have a car. He has something that if you had to sell it, you would get an amount of money. That is extremely beneficial to the persons in whose favor maintenance orders have been granted, and it is used as a last resort. Personally, I would encourage the justice system as well to make use of this, and I would encourage all those who are currently under maintenance orders and who are having this battle to use this route. Why not? It's your children at the end of the day that need to be fed. All right, let me move on. The significant and useful change that came about with the Act was the appointment of maintenance investigators at maintenance courts. Prior to this, we had no maintenance investigators, which meant that we could not go and run traces on these absent fathers. Now, this issue of the maintenance investigators has evolved in terms of the Maintenance Amendment Act of 2015. In fact, in terms of the Amendment Act, if the whereabouts of the father cannot be located by the maintenance officer, the maintenance officer can come before the presiding officer for the presiding officer to give a directive. This directive can include that the presiding officer ask that the cell phone companies, Vodacom, MTN, all the rest of it, be touched upon so that the cell phone companies can try and provide electronic evidence relating to the whereabouts of this father. And that's changed in terms of Section 7 of the Amendment Act. You can have a look at it for yourself. It will be under your Amendment Act. So that's wonderful insofar as one can see that there is some sort of progress that's leading towards tracing fathers more effectively than just the investigators have been. Their assistance to the maintenance courts is invaluable. A maintenance court without the operation of a maintenance investigator is just as well as useless. A lot of the women that come before the court are unable to trace the fathers of their child or children, as the case may be. A lot of them are indigent. So the fact that a maintenance investigator is now part and parcel of the Act cannot be, or the importance thereof cannot be stressed, all right? So they gather the information. From time to time, they actually do assist in serving of the summonses, and they're very effective at finding, locating the fathers and serving the summonses on them. And of course, they take statements under oath. All right. The courts have come to the aid of persons from the time at which the Maintenance Act first came into operation. I've just put 3 cases for you, which you can have a look at if you want. The most important case there would be what we call the Beacon Sweets and Chocolates case, where what the court did was to allow the attachment of pension benefits to cover the payment of future maintenance. So one can see that you can either get the money right now through an emoluments attachment order, you can proceed to execute against immovable property, or you can, in terms of Section 26, now attach the pension benefits to cover the future maintenance. And this, again, very, very handy. The Visser case followed largely, followed through in more case law. Ideally, the Bernsey case, as I've mentioned, does allow for criminal imprisonment. You can impose what we call periodical imprisonment, where you send the defaulter in for a short period of time over a certain period of time. I'm not in favor of criminal action against the debtor, particularly if he is the breadwinner. Placing him in a prison cell is not going to accrue the income that is desperately necessary for the child. So this is seen as a last resort. What happens in the High Court is section for Rule 43 interim orders, pendente lite, we call it, which happens during divorce proceedings. All right. This is a very important case, state versus state and another. The applicant wanted to appeal the Rule 43 order that was obviously against him, and the court ruled that you cannot appeal that kind of order. And there's the thrust of the case at point number 2. Delayed maintenance payments outweigh the dangers of an erroneous interim order. It is far better to make an interim order in favor of the applicant than to have the appeal proceedings take precedence over it. And I think one can understand why. Particularly, and I want to say this in light of the COVID-19 pandemic, in light of the ransomware attacks that has somewhat crippled the Department of Justice system insofar as court machinery equipment has been non-functioning. One cannot stress the importance of making these kinds of orders so that the children at least get some maintenance cover for them. One will know that whilst the ransomware attack precipitated during the period that the courtroom machinery was not working, and that actions and applications could not proceed. Consequently, matters were at certain places being postponed, and the postponements have necessitated a need to now move towards interim orders being granted and moving the applications where there is still a dispute. So for example, your applicant wants 3,000 rands and your respondent can only afford to pay 1,000 rands. They settle the matter at, for example, 1,000 rands, and they come back to court to fight for the remainder of the 3,000 rands or to dispute it, as the case may be. So that's how the courts are kind of dealing with the problem now. There are other challenges other than just what the COVID pandemic has brought with it and what the ransomware attacks have brought on it. And I think your biggest challenge must be the low amount of child maintenance that is ordered. One cannot stress enough how little persons are getting. Orders are being coupled with the SASSA grant payments that some women are receiving. So if you are in possession of a SASSA grant, that money is deducted from your initial application amount because it would be seen that you are that you cannot obtain double maintenance. The second thing will be obviously the stereotypical views and beliefs about the gendered roles of women. Women are to stay in the kitchen, look after the children, the whole barefoot and pregnant approach. This approach needs to change. There are more and more women joining the workforce, and there are more and more women who are in need of childcare services, of a dependence on men in their family or other child care bearers. So this is not acknowledged enough in the Maintenance Act or even in the Amendment Act. And this is something that needs to change. One has to put in some sort of legislated, perhaps, or gendered allocation of childcare, as well as the fact that women are financially dependent on men by and large. And so this is something that perhaps can be looked at for the future. A couple of solutions will then be, obviously, one has to improve the collection of these kinds of maintenance orders. It's obviously going to be impacted by the delivery or online delivery of services. We know that some of these systems completely collapsed during the ransomware attack. So, and this obviously had an impact. We know that the master's offices were largely impacted as well. So that needs to be looked into. What I personally like is to find a financial value for the mother's childcare services, which are not even considered in a maintenance application. One only has to look at the kinds of things that forms part of the application where women have to fill in a figure, and there's nothing there that says mother's childcare services. And we know that a mother's work is never done. We know that she wakes up in the morning and she conducts work to get her child ready for school, probably cooking for when the child returns, gets herself ready, goes to work, and then has to repeat the whole process over and over again, day in and day out. All right. Again, this can have an indirect ability on her to earn money, We've seen from the COVID-19 pandemic, more and more women have, through these studies, they have simply resigned from their jobs in order to look after their children. There's been an increased amount of burnout amongst these women because they just simply cannot cope in the absence of supported services. The other issue is probably to give higher awards of maintenance. And this is something that will need to be carefully considered by the justice system. There are a lot of things to balance, not more so because there are more jobs that are being shed since the pandemic. So there are some more interesting things that are coming in. I have used the following references: child maintenance and child poverty in South Africa. You're welcome to have a look at it. I've also used Resource Center, Save the Children. You're welcome to have a look at it. It's got some good stats. I just want to run through a couple of the important aspects of the Maintenance Amendment Act. I won't be very, very long. There's just a couple that you need to know. I've already told you about the emoluments attachment orders that can be issued in the absence of fathers. So what I want to stress is that for all the persons who want to apply for maintenance, please don't go and apply in the court of your choice. You are restricted in terms of the Act. You can only apply for maintenance, or what we call it, lodge a complaint. You can only lodge a complaint in the area of jurisdiction where you reside, or where you carry on business, or where you are employed. We see a lot of maintenance applications coming into the wrong court simply because people have chosen the court of their choice, shall we say. We've got to send them back. So that's an important point to remember. I've touched upon how important it is for the maintenance court to issue a directive, so that you direct one or more of the electronic service providers to furnish the court with any contact information of the persons to obtain his or her whereabouts, and all you need then is the cell phone number of that person. Be careful, this is a rather lengthy process. Not all the service providers respond on time, if at all. It does take a little bit of jiggling from our side, but we do try where we can. You know that parents have a duty to maintain their children. It is a legal obligation. It extends to anyone who is bound to adhere to that obligation. What I want to stress to you is that you cannot simply dissolve that obligation. Section 6 of the Maintenance Amendment Act has now been changed to indicate on good cause. On good cause. So in other words, if you want to, this is my last point because I can see people are talking. So in other words, if your child finishes matric and wants to study at tertiary level, you're obliged to support the child up until tertiary level, as I've indicated, only until good cause exists to vary or to discharge the maintenance order. Chaps, I've only received 10 minutes. I've gone over time. There's a lot more that I can tell you. The Act is fairly detailed. I've summarized it as best that I can. If you desire more information, please contact me. My email address can be made available. I will just give it to Lebogang so that he can place it on. Thank you, Chair. Thank you to everyone who has listened to me. Thank you all.
Thank you very much. This is the first webinar. We are going to have other webinars. I had already committed the Department of Justice. We will be partnering with them. We'll be coming to Mpumalanga. So when we come to Mpumalanga, we'll give you enough time so that you can be able to present. Even when we go to other provinces, depending on who the SEC IAWJ gives, would appreciate it if you can join us. I know that you are busy, we are in court. However, this is a worthy cause. If we address issues of maintenance, then our GDP will grow.
Yes, yes. Chair, I omitted to indicate that I am currently at this stage representing the SEC IAWJ, and I can confirm that we are going to be rolling out more programs in the future. So I thank you for that.
Thank you. Thank you. This session, I would like to get 3 hands It's in the hands that they were raised before, if there's anyone who wants to ask a question. On the chat, people were sending their questions. So I'll just three. Akir kitlanze kilifa, so that we can finish on time, Akir. So that we can finish.
Where is the list of the sites? In there.
Sanibonani. Oqala ithi ngibonga ithuba, ngibonge initiative ethathwe ugovernment wethu. Ngokukhethekile nibingelele nonke. Kuze ngingayi kakhulu ithi ngithi all protocol observed. Okhulumayo lana uArchbishop Penny Ndlovu or imember ye FBO ku province yase Gauteng and also member of ICRA. President womanyano go South Africa obizwa ngokuthiwa ubuhle bobunye bomanyano, of which ama objectives wethu, part of them ukulwisana ne domestic violence ne gender based violence yonkana. So ngimela ngifuna ukukhuluma ngesector yethu kakhulukazi ye faith, and to say uma sikhuluma ngendaba ye maintenance ngiyacabanga ukuthi akusi abantu kuphela abangawondli abantwana, but ngifuna ukuveza kulendlu ukuthi sinabo abafundisi abayenza abantwana abangawondli. And for me mangihleli lana kukhona into evukayo ukuthi I think niwabizile ama department, ngizwile umphathi wehlela akhuluma nange social development noma engekho ukuthi kodwa uyiphathi yale initiative. So for mina kuvuka ukuthi no CRL bekufanele ukuthi abekhona uCommission of Religious Leaders, so that abaphathi bamabandla nabo uma bengawondla abantwana abakhishwe ekushumayeleni nasekufundiseni izwi. Ngani ngoba mawuthi uyabheka kakhulukazi ungabukela uthola ukuthi yibo abayenza abantwaneni babayenza la ebandleni ngithi yabashintsha shintshana ngabomama khona la ebandleni. So ngibonge kakhulu and ngoba sometimes nabo banayo lento yokuthi bathi abasebenzi ekubeni ibandla liyabaphima lomdoko. So makathe akasebenzi fanele ukuthi kucheckwe nje ukuthi imali yomdoko ithini khona lapho. Engibonge kakhulu futhi yiloko okushoyo akushilo umphathi wehlelo ukuthi kokunye fanele ukuthi sibukele into yebathupili principle. It doesn't only comes from air, but into yebathupili ukuthi senziwe ngomfanekiso wakhe and izwe esilifunda elithi mele simfuze. So fanele ukuthi sicheke ukuthi simfuze kanjani. Ngifuna ukusho ukuthi kulombutho wethu ngiyaqeda mama. Embuthweni wethu sinale program esi-initiatayo yama aftercare program so that sizoyenza i-life coaching ebantwaneni sukela phansi ngoba ngesintu kuthiwa ligotshwa lisemanzi. Amen.
Sanibonani nonke. Lokhulumayo la uMamsindi. Nginibingelele nonke nominister wethu. Nominister wethu ngimbingelele ngaphakathi kwendawo. Ngiye ngathanda ipoint eraise ama extended families. Siyachaneka kakhulu singabogogo. Amadodakazi ethu ayaneglect abantwana. Nabo baba babantwana baneglect abantwana babo. Si end up thina singamagreen sisikhulisa labantwana. And umthetho lapha yana court awusivumeli singabogogo ukuthi sivule maintenance. Abanye bayasebenza abalethi nesent. Uhluleka nokuzowashela umntwana iwashini yakhe azombona abonde nomntanakhe lentombazana. Umfana umntana umthatha umfake kabomfana ugogo uzama ngayo yonke ukuthi ayenze i-support ukuthi asupport umntanakhe umfana ukuthi ambonise ukuthi umntana ugezwa kanjani but umama akaveli. So siyacela ukuthi umthetho usivumele nathi access yokuvula i-maintenance against lama parents wethu.
Yeah,
Amen.
I agree. I agree. Bazawuphendula, there were, no, we'll take other hands after people who didn't raise their hands. There was a hand here, here, and then that one, yeah, the only four, I recognize the only four. We'll take your hand later. Sorry, we'll take your hand later, your hand later.
Thank you, Program Director. I greet you all, Honorable Minister. Thank you for a wonderful program. Now, I just wanted clarity in terms of SASSA. I heard, I don't know if Kutlile correctly, or if you are receiving SASSA or your maintenance court, does it mean ito bato eda ho that money kapa ito ba chelte ya SASSA fela na? That's the clarity that I wanted to find out. Nkara ka utlwa hantle. Ke a leboga.
And okay, there was a hand, yeah, that one, yeah. And then we'll take hands after. We are running out of time. We need to push so that people can go and eat. I'm sure high blood, they need to eat.
Thank
we
you,
must
Program
fast track, yeah.
Director. My name is Julie
Short
Silesicha from TEMSA Child and Family Welfare, all protocol observed. I've got two questions, but the other one, I'm not sure if it was answered by the previous magistrate who was speaking. The first question is when we have children maybe placed in a place of safety, one parent is deceased and the other parent is surviving and yet paying maintenance, but we can't access the maintenance and there is an order that has been garnished to the father. What is the process of accessing such funds for the children? Then the second one, it's when the children have lost a parent and yet placed maybe in a place of safety. One parent is surviving and is working very well, and the child is now above 18 and still has interest of furthering their studies. What is the process of the father contributing towards the child?
Okay, the first one, I think it was a comment about the churches, that the churches must be involved. And then the others, I think you've got them yourselves, and the magistrate here. Yes, you can respond. And justice also can respond. I think the other one was about the grandmother claiming maintenance from both parents, or justice wants to respond to that. And then the other one was the SASSA and the grant. If you can access the maintenance, you can't claim grant. Only people who can't access the maintenance can claim grant. Okay, you'll respond to that. Okay.
Yeah.
Yes, you can respond. Yeah.
Okay. You know, I am touched very much by the input made by Ugogo there. It's again a question of lack of knowledge on the part of our officials. Know how to work these things. Yeah. Put it here.
Yeah.
All right. I was saying I'm very touched by the input here, Gogo. because the officials do not know. Our Children's Act is one of the most beautiful legislations in our legislation book. It has defined the concept,
Thank you.
caregiver. Caregiver is far broader than parent. It relevela the de facto position. You have every right to claim maintenance. I'm so tempted. Yeah, I'll do that. I'll probably be in a meeting or traveling somewhere, but I will also alert my team to that. We must also include it in the training that we are giving to our officials, because we've already trained 6 provinces and then these other issues keep coming up. But thank you, Gogo, for that input. And then yes, I see quickly, to qualify for a SASSA grant, I can a threshold. I think now it's 6,000 rands. If you are within the threshold, then you can ask for both. You're gonna get thrown out only if you are above the threshold.
Oh, okay. There was a question there about the 18 years, if the child has attained 18 years, but ngwana o sa le ko sekolong. But also there was a question about the parent, the one parent has died, the father is alive, the father is working, and then, but the child is at the place of safety. Whether the person who works for the place of safety, or whether the place of safety can claim maintenance from the father. Was that the issue? Or there's already a garnishee to the deceased? Oh, okay. Yeah, it was paid to the deceased. So now the deceased is not there, they can't access it. Yes, you can respond to that. And the 18 years, for Ngwana Hari, it's 18 years. I think the magistrate had responded to that, but.
Yeah. Okay, in response to that, in the case where there's a garnishee order, and unfortunately the one who was the applicant in the main court order has passed away, it's similar to Yaka Gogone, where the child is being raised by a caregiver. So the caregiver must first approach the children's court and apply to be appointed as a caregiver in terms of Section 34 of the Children's Act, because it's only caregivers who can access or who can claim maintenance on behalf of the children. Then afterwards, then the father or the one against whom a garnishee order was implemented must apply to be discharged from the operation of that court order. Because the applicant is no longer there. Then once they've been discharged from that, then the one who's the caregiver can then apply so that we can implement a new garnishee order. So for now, then there needs to be the first process first before they can access. For now, you cannot access because into the bank accounts of the deceased person. And then number 2, the issue the 18-year-old. When it comes to the maintenance of the children, because the Maintenance Act until they are self-supportive. So again, it speaks to the discharge order. Meaning before ngwana atena 18, children accounting ya mama, then papa needs to be discharged from the operation of that court order, and then ngwana apply the maintenance court because of 18, but is not yet self-supportive. But I always say we need to exercise caution because ngwana 18 years so please let us also monitor them. And I encourage parents so that they monitor because of 18 years the comprehension regarding the finances. But kamulao we discharge papa and then apply one but mokape so that we monitor as kayonja ayona di spinza kayona. Thank you, Batswati.
Thank you.
Sorry. Can I just?
Oh yes.
Can I just?
respond.
Can I just?
Yeah, we will
Okay.
come to that. Can we?
I just want to add to that. If the parent is deceased, the executor of the estate can, in the interim, provide the funds to the caregiver until the process that the Department of Justice has just explained occurs, so that there's no long waiting period. So the executor of that estate can then make sure that the money paid into the bank account is then given to the caregiver in the interim, while the caregiver then applies for those applications. Thanks.
niyayizwisisa ukuthi ithini ne umama ushonile bekathola i-maintenance so kune-executor angithi niyazi le nto abathi umuntu uya ku-master ukuthi umaster huye ozodila ne-estate nelifa lalo muntu so into ayishoyo ukuthi uye uyobhalisa ka-master ukuthi umama bekathola iganishi from ubaba and umama sekashonile so imali leyo ngoba ingena ku-estate yakhe i-estate ingabhadala until the process abakhuluma ngayo i-follow up so kusho ukuthi umuntu ohlala nomntana manje une-responsibility yokuthi ayobhalisa ka-master but also ukuthi aye-justice ayobatshela ukuthi umama womntana ushonile ngoba ubaba ngesinye isikhathi ngeke alentozana uzavela ahlala azijulele nje so une-responsibility yokuthi umama ushonile and then i-justice ukuthi either bazomsaphina lo muntu or bazoyenza whatever the processes ekufanele bazenze. Isikhathi sethu siyasishaya so meanwhile I've noted ama-questions abhaliwe nginawo la ngizawanikeza the relevant people ukuthi bawaphendule umuntu oyi-one engizombiza manje Bibi Bayat, Suraya Bibi Bayat, you've raised your hand. Meanwhile, we're asking your question. I would like to thank our panel. Thank you so much. Thank you for your wisdom. And I will call another panel. I'm not sure whether Advocate Mark Morgan has joined us. Advocate Morgan is not here. Okay, I would like to call on Ms.
Hello.
Hello?
Yes, sorry, Bayat.
Oh yeah, no, I said meanwhile, let me call these people so that they come and sit here and I'll give you an opportunity.
Thank you so much.
I would like to call Miss Felicity to join us. Miss Emily Dlamini.
Yes,
Has she joined us?
Yeah, I am available.
Oh, okay. Yeah, I'll give you an opportunity also to present here on what the sheriffs are doing. I would like also to call Mr. Lisiba Mashap to tell us about from the National Credit Regulator. You see what we've done? We've brought everyone here, National Credit Regulator, the traditional leaders, the magistrates, everyone, because we want to close the loopholes. We want to look at every aspect of the maintenance. And then I think what we could do, we could just call all of them. Also, we will call Mr. Lori Grevenstein. He was a magistrate, he resigned, and he has started a foundation, social justice foundation, to address issues of mediation and all those in order to assist women who apply maintenance. There's a lot of wisdom there. He understands all the tricks, and his association is helping many women. You'll hear about what he's doing. He'll also give you his website so that if you have problems, you can register in his website so that they can be able to assist you. He also has people in different provinces that are assisting people. I'm thinking that I should also call you so that you join us here. We have yourselves and Miss Emily Dlamini on the, she's here virtually. So what we'll do, we'll start with Miss Felicity, yes, to present. Let me tell you, you'll cry when she tells you about the stories of women. She also assists women on maintenance. Herself having been a maintenance applicant, knowing the tricks of a rich person or a person who can be able to trick the system and all those. So yeah, I think we will ask the four to present, and then, or before I ask you to present, my apology, Miss Suraya Bibi Bayat. And I indicated that the questions that have been written on the chat, I'll respond to them later. I just want us to be able to finish earlier. Well, we will respond to all the questions that we have been given.
Okay,
Yes, Suraya?
My input is not related to the question. My input is in relation to the beginning and thanking everyone that who made it possible for me to be present here today. And really, I needed to have a question in relation to the input as South Africa. Are we working towards restorative justice or punitive justice? That's one.
And are we working in relation to what the minister said? That the first input was in relation to Mabatu, and that was about the restorative or punitive. But also the minister spoke about the quality of life. Now, when we look at the quality of life and we want to look at justice, do we place the burden on the higher earner? Because there's also, and I know it's been discussed and everyone has given beautiful input. So I really love the input, especially when it comes to culture, religion, and linguistics that needs to be brought into the whole process. Because we find that somehow or the other, we will find that we are over-regulating instead of working towards mediation to get the parties to agree instead of the vindictive and pulling the children apart. That's my input. Thank you so much.
Okay, thank you. I think I can respond to that one. Advocate Petunia Siabi, when she presented, she indicated that people need to be trained so that they can mediate. We've brought mediators here. I indicated earlier on that Mr. Laurie Gravenstein is the co-director of the Social Justice Foundation, which deals with mediation. However, there are instances where mediation doesn't work. So that's where the issue, actually the maintenance system where it starts with mediation. Either people pay maintenance at home, and if they don't agree, they go to the court. Section 6 is about mediation. They agree, they discuss, they agree, and then that person pays maintenance. But most of the time that doesn't happen. The person would say, I can't pay the maintenance or whatever. It goes to section 10. Section 10, they then disregard the court order and all those. That's where the court would come in to deal with those. But those where people can negotiate and come up with a settlement, that's what is being done. So we're looking at all measures to ensure that the rights of children are protected and promoted. Thank you. Yes, Ms. Felicity, you can come in here. Maybe you'll also share in terms of how work, and you had to ensure that the courts work, but still the court's not working.
Good afternoon. Is it working? Can you hear me? Good afternoon, honorable dignitaries, ladies and gentlemen, all protocol observed. Thank you, Program Director, for this significant event. For those that know me, they know that I eat, breathe, and sleep maintenance, and that maintenance is my heartbeat. So I have my own story, but it's no longer only about my story. But my journey took me into what I call the deep underbelly of the justice system. And I started a Facebook group 7 years ago called Child Maintenance Difficulties in South Africa. And currently we have just under 70,000 members. I started the group to be able to assist other mothers. It's also about empowering women on their rights and how to get emotional support. And over a period of time, I started recognizing patterns and forms, because it was my story on repeat, differently, but exactly the same story. And I started thinking about these patterns, and they were all abusive in one way or the other. And then I would notice a link to inequality, and then I would notice a link to poverty, and I would dash off down a rabbit hole and go and do research. And it culminated in 3.5 years ago, giving up my little business that I had to do this work full time. To my knowledge, there was no advocacy prior to this solely focused on maintenance, and that became my focus. And on my group is very interesting because I have people from every single level of government, DOJ, on my group, that I could single-handedly monitor every single court in this country and give them constructive feedback about how their courts are not performing. I can also tell them which courts are performing, and I will name it. Soweto Court, I have the least complaints about. Why? because a court manager was on my group for many years. And she would observe complaints about her court. She would address her staff members to rectify the problem. One of the distinct patterns that I noticed was that the feelings, the experiences that women had were almost identical to women who were experiencing domestic violence, gender-based violence. Not just their emotional, but their physical and mental responses. Women were telling me that they were suicidal. In fact, I had one of my members, after a 4-year criminal case, went and took an overdose of sleeping pills because the magistrate ruled that he was not guilty. I have many mothers who explain a similar response to it. So I'm going to read just 2 messages. My presentation is brief because we all know the problems in the maintenance court, and I'm not going to stand here and lament and repeat all of them. So I have 3 questions that I do want to ask of all of us. But before I do that, I want to just read these messages that I received in my inbox. So I get messages via WhatsApp, email, my inbox. I at times spend 14 hours a day on social media, just monitoring complaints and responding. Here's one. Hi, Felicity. Just want to let you know, I'm not going forward with the coaching for maintenance. After this weekend, I decided my emotional state is much more important than the maintenance towards my son. Been a wreck since I saw him on Friday, and now and know that I cannot face him in court. He just escalated my anxiety to the point that everything is too much for me. Who else has felt like that after being to a maintenance court? I'm happy to give, here's another one. I'm happy to give you my case file at domestic violence. Domestic violence seems to be taking the matter seriously since the Superior came to discuss a matter with the magistrate at our last maintenance hearing. Another one. I'm currently pregnant with my child. I'm scared that he might get arrested for a very long time. I'm really not coping. They took him away today. I feel bad. He did apologize. I was hoping that maybe he can get counseling and he'll be fine. I opened it because he beat me and I got a fracture on my ankle, which I had to do an operation. So I wanted him to learn not to do it again. So the point is that maintenance is not separate from any other form of domestic violence or gender-based violence. It is just another way of being able to exercise control and to be able to manipulate and coerce the victim. So 3 of my questions are, what provision in the Act is there to protect primarily the woman who is making the application on behalf of the child? Mothers believe when they go to court to apply for maintenance, they will be assisted by competent office bearers and therefore do not need to have any legal knowledge or require assistance of a legal representative, and that the Act is purposed to protect the child. Remember that. The mother has a right to dignity and access to justice. This justice is, however, for the child, not the mother. Provisions in the Act to resolve matters as quickly as possible, which are fair and reasonable, by all means possible, do not protect the mother. Because nothing happens swiftly or is fair or reasonable towards the mother, and by default, the child. It is a lack of provision or understanding of gender inequality and social narratives of women being gold diggers, greedy, spiteful, vengeful, that causes mothers to be treated in such an undignified manner by employees who have their own bias. Women speak candidly about being victimized by employees of Department of Justice and legal representatives by proxy. And the systemic abuse is often worse than the abuse they experience in relationship. My next question is, who is the Maintenance Act meant to benefit? The child. Third question, who currently benefits the most from the Maintenance Act? Does anybody want to answer? No, the person who wants to pay the least amount of maintenance or who does not want to pay maintenance. That person benefits the most from the Act because there is so much protection within the Act that protects them. We see that with the postponement of cases, with cases taken off the roll because the woman didn't make it, yet if the man doesn't, he gets a telephone call or he gets another date. The woman has to start from scratch again. I can go on and on and on. But the person who's trying to pay the least money benefits from the Maintenance Act. That's the practical reality, not how the Act's purpose. Please don't misunderstand me. In reality, who benefits most from the Maintenance Act? There is a need for increased and targeted efforts to make gendered equality more practical instead of remaining an abstract concept. Enforcing maintenance would deal directly with economic inequality of women. More than 3/4 of children are grant beneficiaries, while it is unclear how many of these children live in single women-headed households. 460 Rand is a child grant, and this is substantially below the food abject poverty baseline of 624 Rand per month per person. And this includes shelter, education, healthcare, and clothing. That is food abject poverty baseline. So maintenance would alleviate food poverty for many children and fulfill their constitutional rights as mentioned above. Even if a mother has a middle income, she is still economically disadvantaged if she's not receiving any child support. It would also make a substantial impact on the SDG of 2030 to alleviate poverty and inequality. The way violence is defined is not only academic, it has real life harmful impacts. Non-physical violence is just as violent. It has dire practical, social, and economic impacts. Intentionally or unintentionally not paying child support is a form of abuse. Financial abuse is a silent but no less violent form of gender-based violence with an intersectionality to economic inequality and poverty. Financial abuse is a subcategory of economic abuse. And the different views that constitutes violence and abuse will lead to different policy decisions and the allocation of state resources. There is no clear definition or data available on the prevalence of financial abuse or what constitutes financial abuse. Women's lived experience and preliminary figures from my own research that I launched a couple of months ago to establish the prevalence and extent of financial abuse shows distinct patterns of abuse, how money is used to coerce, manipulate, and abuse a mother and therefore by default the child. The first intentional act of abuse occurs when the mother leaves the relationship or the relationship ends. The money is cut off immediately. And then it changes shape and form. And the only control left post-relationship, well, not the only non-physical form of abuse post-relationship is through money. The withholding of maintenance is a violent form of abuse, not just against the mother, but the child as well. Paying maintenance beyond the 30th of the month is a form of financial abuse because it causes emotional stress on the mother. The mother has to phone the father, not taking into account what that relationship was, but assuming worst case scenario. She has to phone the father and go, when are you paying? And then it opens herself up to verbal abuse. And then her debit orders bounce. And then she has to pay fees for the return debit orders. Does she get those back on the maintenance arrears claim? She's lucky if she gets interest. And then she has to go to court. And then there's no urgency. The mother goes back to court and says, it's 3 months now that he hasn't paid me. I'm about to be evicted. I've had my water cut off. I've had my lights cut off. This is now urgent. Sorry, we're still trying to find him. We've asked the maintenance investigator to speed this up. I'm about to go and live on the street with my 3 children. Please, can you help me? I'm desperate. My family can't help me. They're also desperate. Sorry, our hands are tied. We have to follow process. This is a story that is repeated day after day after day. Is this not serious enough for anybody? We should all hang our heads in shame, every single one of us. We've let our own kids down. Society's let children down. And as people who are in positions to protect children, they have let our children down. And they've let us down when we are trying to protect our children's rights. I ran this survey on my group just to give them a chance to raise questions that they're unhappy with. I've left them for various ministers to have a look at, and I categorized them: applicant, procedure, respondent, magistrate. The greatest complaints come under procedure. So that reinforces that we have a Good Maintenance Act. It's the implementation of that act. That's easy to fix. Political will, policy, commitment, allocation of human and monetary resources, we can get that right. We fortunately don't have to go and get a whole bunch of new laws. And then I just want to finish off with being very mindful of our narratives. I'm incredibly aware that maintenance and access are 2 separate things. However, there is an intersection and we can't ignore that. And there is a huge need for men to be heard, men to be understood. It is equally as complex trying to co-parent in a country that comes from such a painful, traumatic past like us. It's not the only, but it does speak directly to the level of violence that we experience in this country. So with compassion and empathy, yes, men need to be heard. However, I have a concern because I'm recognizing that while there's this need to work with that, because that's how we prevent domestic violence, intimate partner violence, and femicide. But this report, State of South Africa's Fathers Report 2021, I was at the launch on Thursday and on Friday. I made a small contribution to it. The amount of money spent doing this research and producing this, where's this kind of report for women? State of South Africa's mothers, 2022. Can we look forward to one of these? In this, it speaks to emotional, psychological, financial, historical. My concern is the narratives. They did the research amongst 1,000 cohorts. And in this, they print in here 76% paid maintenance. This is what has been reported in the press since then. So we are sitting here going, there's a crisis. And this narrative is being put out there that no, 76% of men are paying. I did a poll on my group. Over nearly 60% of men, 60% of mothers were getting 0. And that trajectory follows very closely with absent fathers. We can't ignore that they are related. How we resolve them is by working together. I'm not anti-men. I've often been accused of being a man-hater because I stand and fearlessly speak on behalf of women. And they fail to see that I have the ability to equally stand with compassion for men. So we have a long way to go, but today is a great start. Thank you, Minister, Director General.
If you are a man hater, then there are women haters. You know, always you raise these things with passion. You use your experience to try and empower other women. And this is what women do. Women work with consensus, women assist other women. Women will always come together and say, without the resources available. And yes, there are men who also will come in and say, we are doing this for women, but it's just that for now we were focusing on this one. I would like to call on Mr. Lisiba Mashapa. He's representing the CEO of the National Credit Regulator, because the Act says people who don't pay maintenance, people who have defaulted in their maintenance payment where there's a court order must be listed. But there's so many stories. I know that they say they've been listed. That I think when I was still in justice, I've been in this matter of maintenance long ago. We once invited a sheriff who said to us, before we can attach any property, a woman must pay a certain amount. I don't remember how many thousands, lots of thousands before they can go and attach, lest they come back and sue them. So we need to hear, we'll also hear from Miss Emily Dlamini in terms of how do they do that? How do they attach or try and...
Good afternoon, everyone. I'm going to start by observing protocol also. First of all, to pass our greetings to the Minister, the DG, and all other dignitaries, and the mothers who are gathered here today. As I was listening to you and your painful stories that you were explaining about we fathers who are not taking the responsibility to look after our children. It's actually very, very sad. And I'm also very ashamed to hear of these stories because we don't normally hear about them every day. But I want to assure you that I'm one of the few responsible fathers in South Africa, if there are few or many of them. I live with my two daughters and their mother. They have lived with me throughout their lives. One of them is 17 years old, another 14 years old. And I also pay their school fees all the time and on time. Yeah, thank you very much for this opportunity that you have given the NCR to come and take part in this event. First of all, I'm going to briefly explain to you our regulatory mandate. We regulate consumer credit in South Africa and the entire consumer credit market. In the credit market, we have a segment of credit information reporting. Oh, they've put up my slides. Yeah, we have a responsibility to regulate the consumer credit market, and part of that includes the reporting of credit information to the credit bureaus. We have established a specific regulation which enables providers of credit to report loan information to the credit bureaus. The next slide. We currently have about 5 main credit bureaus that we call primary hosting credit bureaus. These are the credit bureaus that we have accredited to host large databases of your personal information relating to credit. And then we have one credit bureau, which is responsible for hosting rental data. It serves landlords in the rental market. And then we have 36 companies that we have accredited who buys information from the primary bureaus and sell that information to their clients. Now, the reason why I'm explaining this to you, it's because the next slide you will see, it's because of the 2015 Maintenance Amendment Act, which requires the maintenance officers and clerks of the courts to report maintenance defaulters to credit providers, businesses that are providing credit, we call them credit providers, and then also to businesses that are involved in the credit rating of persons. We understand that many people believe that this Amendment Act requires the maintenance officers and clerks of the courts to report maintenance defaulters to credit bureaus. But when we read how it is written, how the act is written in the amendment to section 26, we do not believe that credit bureaus have been included in this amendment. So there was probably a mistake, and that mistake happened because there was no consultation between, it's either the Department of Justice or the Rules Board, whoever was responsible for compiling this Amendment Act. There was no consultation with the NCR. We checked with the Credit Bureau Association. They have actually spoken to someone in the Department of Justice who advised them that indeed credit bureaus have not been included in this amendment. And this is very sad. So what then this means is, as a regulator of credit bureaus and the credit bureaus, we have no role to play in the reporting of maintenance defaulters because the credit bureaus are not mentioned and the NCR's role has not been defined in this amendment. It simply means that we, on our side, we have no regulatory mandate over this. And then secondly, the credit bureaus have no right to receive information about maintenance defaulters. And as you see in the slide, I have explained that the reason this problem exists is because there was no consultation. And even we were not even aware that there was this maintenance amendment bill at the time when it was in the public consultation process, because we would have alerted the department to the deficiencies in the amendment to section 26. The next slide. So as I've explained to you, the impact of the lack of consultation is that the role of the regulator of credit is not defined in the amendment. And as a result, it has no regulatory mandate or authority to supervise the reporting of maintenance defaulters to the credit bureaus. And then also we are of the opinion that credit bureaus have been excluded from this amendment. And then lastly, we also know that many credit providers also do not understand the rationale why details of maintenance defaulters should be reported to them. And I tell you why they say this. We have probably about 9,000 credit providers. So if you tell a maintenance officer to report a maintenance defaulter to 9,000 credit providers, practically, how will they do that? First of all, they don't even know who these credit providers are. Whereas if this requirement came in this way, that the maintenance officers must report the maintenance defaulters to the credit bureaus, then the maintenance default will be recorded on the profile of the defaulter. What it then means is all the 9,000 credit providers, if he applies for credit with one of them, will be able to see that so-and-so has defaulted on maintenance, because that default will be recorded on the credit profile. You see how easy it could have been if this act was formulated properly. Because all what you need is to send that form, I think it's Form W in the regulations. You send it to the 5 credit bureaus, and then they upload it on the credit profile of the defaulter. All credit providers who have dealings with this person, if he applies for credit, they will be able to see that he has defaulted on his maintenance. It's as simple as that. And we could have done this if there was proper consultation. My last slide is I'm just calling on the department and the department which is hosting this event that let's have a proper consultation. Let's reformulate these amendments because we want to help you to achieve your objective of reining in maintenance defaulters. We believe that is a noble objective, and we have an important role to play as one of the institutions that has been established by our government to support other government departments. Thank you very much.
Thank you. I think your presentation has been very helpful. I think between ourselves and Justice, we have had, and we are going to take this forward. So thank you very much. Before I call on Mr. Laurie Ravenstein, I would like to call on, I know that maybe she'll say what you've said. She's a sheriff in Centurion East, Miss Emily Dlamini. She might tell us what is it that she's doing, because you know, women who are activists, you put them in certain positions, they find a way of addressing the challenge. Emily?
Good afternoon. Good afternoon, Program Director, and good afternoon to all protocol observed. My name is Emily Dlamini. I'm the sheriff for Centurion East, as the Program Director has already indicated. Let me also indicate that I am not representing the South African Board for Sheriffs, nor do I represent the chairperson of the South African Board for Sheriffs, Mr. Morgan, but I am going to talk about the responsibilities of the sheriff. Having heard since this morning all the issues that have been presented and the challenges that are faced by women who expect maintenance money to be paid, clearly I also think that as sheriffs, we have a role to play. And we as sheriffs are appointed by the Minister of Justice, and we should exist to support the processes that are decided upon in our courts. I was a regional head in my previous life, and my colleagues are also there. I was responsible for the province of Gauteng, and I know the challenges that are faced by our courts. The very first one that was confirmed by Advocate Siabi is the shortage of staff. And amongst the staff that Justice is struggling with, it's maintenance investigators. But as sheriffs, we have our responsibility is to serve communities and is to execute court orders. But there is no uniformity in most of our courts, and those decisions whether matters should be referred to sheriffs lies with the court managers. In some jurisdictions, matters are referred to the sheriffs, and in other jurisdictions, maintenance investigators are dealing with those matters. And it's not all the courts that have maintenance investigators. So we cannot deny women who apply for maintenance an opportunity of having their services being attended to speedily because there's no maintenance investigator whilst we've got sheriffs. I've also heard that there are instances where sheriffs will require applicants to pay upfront before they can go and serve. That is very unfortunate. Really, we cannot have that kind of a situation. And my request is that we need the Department of Justice specifically to engage with Advocate Morgan, the chairperson of the South African Board for Sheriffs, and engage on what can sheriffs do to enhance this process of maintenance. Speaking about myself, I do not charge a cent for maintenance matters in my office. I do not charge a cent for any gender-based related cases that comes to my office. But I cannot sit here and say all sheriffs must do that. But if we engage the chairperson who is really here to work, who has already brought a lot of changes that will improve the manner in which sheriffs are operating, I am sure he will definitely listen to the challenges that are faced by the court and bring in the role that the sheriffs will play to enhance the enforcement of the Maintenance Act. So it's not much that I can say because I have not been mandated. I can only share that which I'm doing in my office. But there is that possibility of engaging with the chairperson and engaging with sheriffs in general on how best can we assist in dealing with maintenance maintenance cases. As I've already indicated, I don't charge in my office. We go out, we attach movable and immovable assets. I have sold cars of maintenance defaulters, and whatever money that I receive from the public auction, the whole of that money, without me taking any fee or any cent, I will pay it over to the maintenance beneficiary. So it's something that is doable. We've got a responsibility as South Africans, to pay back into our communities by just rendering that kind of service. So my request is that let's engage with the chairperson of the board, Advocate Morgan, who I'm aware that he is out of the country at this particular stage, but maybe on a one-on-one with the Department of Justice, and I'm prepared to use my office as a pilot. I'm already doing it. I'm not charging. So we can use my office as a pilot and other neighboring sheriffs that are willing to continue with this good cause. But thank you for inviting me and allowing me to participate in this good cause.
Thank you. Thank you very much for sharing your experiences. This is important because it shows that it's doable, but also you put a woman, she understands the issues. She understands the issues. Do you want to ask a question or? Oh, okay. Please, it's not yet time for questions. Do you want to ask her? You are a trauma counselor. We are the one who sent this piece of paper. Yeah, no, I will read it. It's okay. We can't hear. We can't hear.
They're letting you.
Good day. My name is Andy. I'm a board member at Ituseng Center with persons living with disabilities in Ekurhuleni, Clorgop, and I'm also a chairperson of my own NPO, Pure Campaign. I'm a counseling psychologist by profession and I work as a trauma counselor at CPF. I would just like to have a plea to the minister and your department to please, may we try to create more trauma centers, because we're experiencing a high volume of people with abuse problems and old elderly grandmothers with nyaupa abusing sons, especially in Ekurhuleni. Thank you.
Yeah, you have sent a letter. I would read it later, because we also have other questions that we've not responded to. I said I will bring the answers later so that we can finish. I would like now to hand over to Mr. Lori Gevensen. As indicated that he was a magistrate for a long time and now he's focusing on maintenance. Thank you. Over to you.
Thank you so much. There we go. Good afternoon, Honorable Minister, Advocate Maluleke, Advocate Siabi, distinguished guests, dear colleagues and friends. I thank you so much for this opportunity. I'm really honored to be here today. Thank you, Felicity, for introducing us to Advocate Maluleke. It's an absolute pleasure to be here today. There's another person that I would like to give honor to, and that is to my dear wife. She's here today, and she's really the fire behind a lot of what's happening in terms of what we are doing in the field of maintenance. Thank you so much, Annika. The Social Justice Foundation, we focus mainly on alternative dispute resolution. And during COVID, we have started dealing with disputes online, and there's a lot that can be done online. I must just tell you, we have settled so many cases, but let me continue. It's kind of difficult to, next slide, yes. Kind of difficult to start somewhere, but I must start somewhere, and maybe I must start way back on the 1st of December, 1987. On that date, I was appointed as a maintenance officer nearby. 34 years ago, I touched a maintenance file for the first time, and I've never stopped touching maintenance files. Like Felicity, who's breathing and sleeping and eating maintenance matters, that's exactly what we do. We have a slightly different approach to that. I'm not an activist opposing the maintenance system. As we've heard, we've got a wonderful piece of legislation. Unfortunately, the implementation thereof is problematic. I would rather like to see myself as a social entrepreneur who finds alternative solutions in creating better lives for my fellow South Africans. I've been in a formal justice, working as a maintenance officer, a public prosecutor, and on the bench as a magistrate for 15 years, altogether 25 years that I've spent in the formal justice system. But since 2006, for the last 15 years, I find myself in informal justice, alternative dispute resolution, appropriate dispute resolution. And there's a lot of opportunity there. I must just tell you, I'll come back to some details a bit later. Then it became apparent after we started dealing with maintenance cases way back in 2006. So what I did, I was on the bench as a magistrate dealing with maintenance cases every day of my life. The average court in South Africa at that point in time was finalizing 1.3 cases per day. I found myself in the maintenance court, and I pushed myself finalizing approximately 12 cases per day. Arrears maintenance, okay? Not maintenance inquiries. And then I realized, but we are only scratching the tip of the iceberg. I resigned my job as a magistrate. My wife encouraged me to start dealing with maintenance matters, but in alternative ways, appropriate ways. I walked onto the Cape Flats, we from Cape Town, and I did this. Anyone out there with maintenance problems? The biggest mistake of my life. I was completely overwhelmed with people who came to us and reported problems with maintenance about their maintenance to us. We had to close our website. We had to switch off the telephones. In a very short space of time, about 10,000 maintenance cases were dropped at the door. And we had to do something. So in an alternative way, we learned a lot of lessons. We had a call center with 18 people making phone calls, mostly cases of arrear maintenance. So initially I would make the phone call and say, hello, Felicity, this is Laurie speaking. No, let me start over. Hello, John, this is Laurie speaking. I'm phoning on behalf of Felicity. Then he would say, what? Felicity, I don't want to hear from that woman. Go away. And he would put the phone down. So I had to change my approach completely. I would then say, hello, John, this is Laurie speaking. I'm phoning about little Johnny. You mean my son, Johnny? I say, yes, your son. Is he okay? Well, he is okay, but I think he can do better. Why? What's wrong? Well, there seems to be a need, and I think you can help. Really? Well, you know, I can help you to keep this case out of court. Can we settle the maintenance, please? Now, we were collecting arrear maintenance. We were 80% successful collecting arrear maintenance. Now, it was all about the approach. On my next slide, before I continue to the next slide, we then realized, but we have to speak to people in a different way. I cannot phone people and threaten them like a debt collector, or phone someone from the court and say, there's a summons for you. What do you do when you receive a summons? You're upset, you're angry, you don't like it, okay? We have to do something different, and that's exactly what we did. So I became a trained mediator myself, family mediator with Anneke. We started training other mediators. Up until now, we've trained about 1,600 mediators. We still focus on maintenance matters. I've trained about 2,000 people just dealing with maintenance cases, different aspects of maintenance cases. You don't have to be a lawyer. You don't have to be a psychologist. You don't have to be a social worker. Luckily, since the 1st of December 2014, we have Court Annexed Mediation, which now makes provision for a person with a matric qualification to be trained as a mediator. Okay? So where do I take them? I take them to maintenance first. I train them how to deal with maintenance disputes. On my next slide, the problem is that we start out with the law first. It's not a friendly process. It's not nice going to court. It's not a friendly environment to be at. There are other ways to do things. Now, the litigation process is a strictly formal process, whilst mediation, conciliation, peacemaking, and dialogue are informal mechanisms that can help people to go forward. I would like to move to my next slide. So part of the problem is that we really have capacity issues. In the middle of 2018, South Africa had a population of 57.7 million people, of whom 19.7 million were children under the age of 18 years. About 2 or 3 years ago, the Minister of Justice announced that 67% of children in South Africa, listen carefully, do not grow up with both biological parents. It's about 13 million children. They do not grow up with both parents in one house. I've made some calculations. We have 350 magisterial districts in our country, 251 working days. Maintenance orders need to be revised on a regular basis. Why? The cost of living goes up, etc., etc. We have to revisit those maintenance orders. If you do the calculation, on average, every single magisterial district must finalize something like 148 cases every single day. It's impossible. And this is what we must realize. If we want to win the problems around maintenance, we must find something completely different. No act will rectify this. No maintenance system will ever be able to deal with the problem. I was told some time ago that about 70% of all non-custodian parents fail to comply with their maintenance orders within the first year. Now, when I started out with this venture, I went to the Mitchells Plain Court one day, 15 years ago. I spoke to the maintenance officer. I asked her, do you have cases of area maintenance here? Yes, absolutely. How many of them? It's about 50,000. I made some calculations after I've asked her, do you have a dedicated court to deal with these cases? She said, no. So how do you deal with them? We send them to the criminal court. You know, if there's a case, then I just allocate them. I just send them to the different courts. Now, I realized they were not really serious about dealing with these cases. So I made a calculation for the maintenance officer. 50,000 cases, 350 magisterial districts, 251 working days, blah, blah, blah. At the rate of 1.3 cases finalized per day, listen carefully, it will take them 153 years just to work through those cases of area maintenance without adding any new ones. There's a capacity problem. We will never be able to address that unless we find something quite unique. A lady phoned me from the Roodepoort district the other day. She said to me, Laurie, please help me. I've been to the Roodepoort maintenance court 58 times now. I don't have leave. I cannot go back to court. I can't go back. Now, I've trained some of the staff at the Pretoria Maintenance Court. They put something like 75 cases. Now, that's a very big magistrates court, okay? Very large area. They place 75 cases on the roll on a day. And if they finalize between 2 and 4 cases, they had a great day. We've got a huge capacity problem. We must find something different. Okay. Mediation is one of those. I'm not saying mediation is all of it, but mediation is one of those. Up to 80% of cases settle after only one conciliation session. After only one session. Eventually, in mediation, 90% of cases that do submit to mediation settle. I've taken a look at the figure of 200,000 in the notes, Advocate Maluleke. 200,000 new applications 7 years ago. And that was with a population of 54.54 million people in South Africa. This is now 7 years later. We now have a population of 59.31 people, 31 million people in South Africa. Now, I find that figure a bit difficult because with 67% of children not growing up with both biological parents, the number of 200,000 is way too low. The need is actually 804,000 every year, new cases, new applications. I've done the calculation. I would like to go to my next slide. It's going to just go one back, please. Back. No, sorry. It's just, it's slide number 6. Yeah, there you go. So this is what we did. Between 2006 and 2008, we followed a very long process of blacklisting maintenance defaulters, and we have blacklisted in the vicinity of 9,000 maintenance defaulters. Was it successful? We were extremely successful. That's why we have been 80% successful in collections following different ways of dealing with our clients. Okay. This was a very long process because the Maintenance Act did not make provision for the blacklisting of maintenance defaulters. You had to secure a conviction first, and then you had to apply, and the maintenance officer had a choice whether they would allow you to circulate that information or not. So we went through a civil process, and we got another civil judgment against the maintenance defaulter, and then only listed the person for not complying with the maintenance order. The next slide, please. Now, dealing with maintenance cases is not always easy. As a mediator with 15 years of mediation experience behind me, the next slide, I would like to speak about mediation, some biases, the Pareto principle, and some personality disorders. Now, the people that we are dealing with on a daily basis are not always very nice with us, okay? Now, listen to this. Mediation is not informed by law. It's been informed by the fields of economics and psychology. And this is why mediation is successful above the law. There's an attribution bias that stereotypes custodial parents as loving, caring people, and non-custodial parents or most of them with a personality flaw as being unreliable abusers who don't care about their children. Now, when I was a maintenance officer, I thought so. When I was a public prosecutor, this is where I was. When I was still on the bench as a magistrate, this was my mindset. Until I started out dealing with maintenance clients in the private sector. The Pareto principle tells us that 80% of the cases that we deal with need 20% of the effort, and 20% needs 80% of our effort. For some reason, we are focusing on the 20% and not the 80%. We must work around that. Worldwide, the prevalence of any personality disorder is 9.1%, and borderline personality disorders 1.4% of the population. I'm just asking, is this coincidental? Is this why we have a success rate of 90% cases that do settle in mediation? Maintenance cases are often emotional by nature, and it must be managed carefully. So over the years, we have learned cases are not the same. We deal with individuals, and as a mediator, you have to identify quickly, is this going to be a 20% or an 80% exercise? Okay. Now, maintenance orders, this is where they come from. Divorce courts on a decree of divorce, in divorce settlement agreements, in divorce matters, in interim orders pending divorce from a Rule 43 or a Rule 58, where people apply for maintenance pending divorce. And then the fourth document there is a parenting plan, which can be made in order of a court, a divorce court, a children's court, or a high court, or it can be registered with the Office of the Family Advocate. I'm not so sure about the registration at the Office of the Family Advocate. Advocate Siabi says that's on track. But the bulk of the maintenance matters are dealt with when we deal with parenting plans. Now, in terms of our Children's Act, listen carefully. It makes provision for 4 parental responsibilities and rights: contact, care, guardianship, and maintenance. Yet, and we have trained something like 400 social workers dealing with parenting plans. They finalize here in Gauteng 48,000 cases per year. They tell us if they put a maintenance order into a parenting plan, the magistrate does not want to authorize that. Yet they've been trained in how to do that calculation. Now, 48,000 cases here in Gauteng is a lot of maintenance orders. Okay, that's something that we need to address. I have found that social workers are probably the best qualified people to become family mediators. They are excellent. I have a legal background, and I stand in awe when I see what social workers are doing in this field. Okay. The next document there is a parental responsibility and rights agreement in terms of Section 22 of the Children's Act. Sometimes grandparents, for the sake of having contact with their grandchildren, are willing to even make contributions towards maintenance as well. So there's another maintenance order. And then in the maintenance courts, most of the maintenance orders are made in the maintenance courts. There are different kinds of maintenance orders there. My favorite is the consent and maintenance order, which is made on a Form J214E document. Now, that's where a family mediator sits down with the parties. They settle the amount of maintenance, and the Form J214E is then taken to the magistrate in chambers. And the parties do not even have to be present at court. So we had a conference the other day, and I had a local magistrate there from the children's court and the maintenance court. And I explained this to some of the participants there, and then the magistrate said, "Not in my court." A magistrate is a creature of statute. What does that mean? They can only do what the Act allows them to do. Yet they decide to go against this, and they have reasons for this, their own reasons. Some other orders can be made there as well, orders by default, if the respondent is not present on the day of the hearing. And then in children's courts, there was a question earlier today, and this deals with contribution orders. If a child is in the care of another person, the children's court can make a contribution order towards the maintenance of that child. And then obviously, some people have already spoken about domestic violence orders, where you can also get a maintenance order. Would like to go to the next slide. I will briefly touch here. This is a comparison between the different processes that happen around maintenance orders. So you can either mediate. Now, the mediation process is confidential. It's a voluntary process. It empowers the parties. It's a neutral process where unique solutions are possible. If you compare that to the investigation done by the maintenance officer, as well as the inquiry by the magistrate later, the benefits for participating in mediation is way above. Okay. Would like to go to the next slide. In mediation, we work with 4 mediation models. I prefer to focus on the last 2 when I deal with maintenance matters. It's known as transformative mediation. We often have to teach people the right way. As a mediator, you can do that. And then evaluative mediation. You can maybe just mute that participant. Evaluative mediation, also known as advisory mediation, is where a person with specialized knowledge in the field of maintenance can sit down with the parties and guide them through the process and get them to agree on the new order. My next slide is basically a comparison between maintenance enforcement options. There we go. Now, arrears maintenance, there's a criminal process as well as a civil process. I would rather prefer for parties to not make use of the criminal process. Really, it's a difficult thing to go through, and very often, if he says, but I was unemployed and the state cannot prove that, he will be discharged. But if you follow the civil process, you can attach his things, his movable and immovable things. You can attach his income, and you can attach debt, including a pension fund. It's a matter of paperwork. These are all processes that we do at Social Justice Foundation as well. I'll get to the online options there. I would like to go to the next slide. On my next slide, I have a quick comparison between civil processes, civil debt, as well as arrear maintenance. Now, with a civil debt, if a person did not pay his civil debt, the matter will be handed over. It will be dealt with in the magistrate's court. In terms of Section 129 of the National Credit Act, there will be a letter of demand and summons will be issued. In many cases, a judgment will be taken by default. That will be a court order that's valid for 30 years, and the information can be handed over to the Credit Bureau. Now, Section 24 of the Maintenance Act is a comparison of maintenance, arrear maintenance, and these processes. You do not have to apply for another court order again because you have a court order. The court has already said you must pay X amount of maintenance. Okay. Unfortunately, there's a contradiction. In the clerk of the court cannot finish the warrant, the necessary warrants, and there's unnecessary paperwork to be signed off by a magistrate before that can be done. I'm going on to my next slide. What is the solution? The solution is known as ODR, online dispute resolution. The whole world is moving in the direction of where you can do everything on your telephone. Okay, you can report your maintenance dispute on our website. You can do your first application there. You can do an increase or a decrease in maintenance. You can report your arrear maintenance matter there. If it is not settled between the parties via ODR, online dispute resolution, it can be escalated to mediation. And your last option should be litigation. On my next slide, I'm saying the litigation process is an outdated process. We should start with dialogue first. A lady came to my office the other day. She said, Laurie, my son is 18 years old. He's going to university next year. There's no maintenance order for him to go to university. Please tell me how must I go about to go through the court process. So I asked, are you still on speaking terms with your ex-husband? No, we're not. We just, my son doesn't love his dad. He just needs his money. I said, no, it doesn't work that way. To make a long story short, what does your husband do for fun over weekends? No, well, he's a keen cyclist. I asked her, your son, does he have a bicycle? No. Well, get him a bicycle immediately. 3 weeks later, she phoned me. She said to me, my son is now cycling with his dad. His dad is going to pay the university fees. What was that? Dialogue. Did I get any money for that? I didn't get any money for that. I just gave her some advice. Okay. Peacemaking, conciliation, mediation, before you move on to litigation. We must change our minds around this whole thing and start talking to one another. Okay. So there are different processes that can be followed in terms of appropriate dispute resolution. There are non-binding forms of appropriate dispute resolution and binding forms thereof. I've covered most of them. And then briefly, I've trained a guy of 78 years old. His name is Uncle Carl, as a mediator. 3 years later, he came back to me. He said to me, Laurie, in these 3 years, I've done some community work at the courts. I have done 277 cases. Now, he's not a lawyer. He's not a social worker. He's not a psychologist. He was working in the financial field. 196 of those matters were parenting plans, etc., etc. To make a long story short, he was successful in finalizing 82.67 cases. You don't have to be a lawyer. Okay, so the turnaround strategy, we start out with dialogue. If it doesn't work, we move on to peacemaking. If that doesn't work, we move on to conciliation, then mediation before we go to court. How do we achieve those? Through ODR. We start out with ODR, online dispute resolution. Now, I would like to invite you on my next slide. Will you please move on the slides to the black one with a question mark on, please? There we go. If you go to that website, it's part of the social justice website, www.maintenanceorders.co.za. You can report your matter there. Okay. We also assist people to gather information to make available to credit providers. But that discussion I will have with Mr. Lesiba a bit later. We've got a whole system that's been put together. Anneke is in charge of a lot of what's happening there. There's another exercise there, which is known as First for Families, and it focuses on maintenance matters. Okay, I thank you so much.
Thank you. This is the first meeting that we have. We'll have other meetings. And I think we started a bit late. But I think people that are here and civil society organizations that are here, they have had, and I hope they've taken the website so that they can register, so that also they could be trained, because also it would assist people, those that are unemployed and those who have a legal background, they understand the act even better, even though everyone can do the mediation. So it could really assist people. There were two questions I think that I gave to Justice one or two questions. I'll request Justice to respond to that. But I think we have tried to push the time. We would even finish later, but I realized that some people left their homes in the morning. They have not yet eaten. We have little ones here that are busy on the tables. We have young ones that are hungry. So we must make sure that they find the food they can go and eat. I liked the way we finished the webinar. We started with what the law says, what's happening, what is it that we can do and whatever, but also came to, actually, we're not supposed to be starting in the courts. You can just pay maintenance and all of us will be happy. If not, there will be mediation. If not, there will be many processes before we go to court. But if even when we go to court, you still don't pay maintenance, then we are going to fix the issue of listing. We're agreeing with our colleagues from Justice that the law needs to be amended as soon as possible to ensure that the listing happens. But also the arresting part of it, people will be arrested. But the other part that I would like the act to include is that one of those that drive German cars and they are globetrotters, they are traveling the whole world. We want them to be arrested at the airport like fugitives. You know, fugitives are arrested at the airport when they go and when they go to catch the flights. We also want to do that. Let me give Justice some time to respond. Department of Justice nako ya gore e arabe. I hope le utlwile the way le invite-ilweng ka teng, le na le email ya ko mmerekong. If le batla go botsisa dipotso further, mani nemibuzo eminye enifuna ukuyibuza, ni emailele i-Justice izakwazi ukuthi nincede. But also I hope nithathile i-website nizakwazi ukuthi nibuze imibuzo. Also Basadi Bamlao bano website, South African Women Lawyers Association bano website, is South African chapter on international, in South African chapter of the International Association of Women Judges, nabo bano website. You can ask from all of them. But I would like to thank all of you. I would like to thank our minister. I would like to thank Basadi Bamlao. I would like to thank the IAWJ. I would like to thank Saul. I'd like to thank Social Justice Foundation. I would like to thank Felicity, everyone, the Department of Justice, everyone who's presented. We are making a difference in people's lives. We are busy. We are flighting in YouTube. People will have this information. People will be able to refer to this information, but also will continue working together to ensure that we address the issue of maintenance. We improve access to maintenance. South Africa is part of the world. We always call ourselves, we are a member of the global community. South Africa has to report in 2026, it has to report in 2030, 2026 on generation equality. They're saying by 2026, we should have ended poverty in South Africa. Just imagine where we are. 2026, will we be able to end poverty? And then 2030, the SDGs, Agenda 2030, Sustainable Development Goals, we have to report on that. So this is part of the process of trying to ensure that we address poverty in South Africa. Yes, Department of Justice, you can come in. There were two questions.
Thank you very much once more. I'll take the one that relates to the father evading maintenance on the basis that the child does not use their surname. We spoke from the beginning that the duty to support or to maintain results with both the parents in accordance with the needs of the children and the means of the parents. So therefore, if you are a mother or a caregiver that is taking care of a child and the other parent is not assisting you, please approach the maintenance court with the following documents. It's very, very important. Number one, your identity document. Number two, the birth certificate of the child, alternatively the proof of birth, because we do have those mothers whose children do not have the birth certificate. So the fact that your child does not have a birth certificate does not mean that you cannot claim maintenance on behalf of the child. Thirdly, please also on the side, please develop what we call the list of the needs of the child, because most of the times we go to the court without actually having reduced them down into writing. For instance, write how much it's cost for the child's school fees, the child's transport, electricity, water, and etc. And then finally, you also need to provide also your banking details. Somebody spoke about the garnishee orders earlier on. We support the implementation of a stop order. As soon as the order is issued, please request that the respondent allow that the money comes from their salary instead of you having to fight with them. With a stop order, it makes things easy because it does not have any negative effect on the salary of the defaulter or on their credit profile. It's just mainly from this salary then to their to the complainant's bank account. Thank you.
Thank you. Thank you, Minister. I had already thanked you so much for your support. Labona Minister serious. She sat here, Minister busy, but she sat here from in the morning because she wanted to hear what is being said. She wanted to listen to the suggestions for the improvement of the maintenance system, because maintenance system is part of the economic empowerment of women. Minister, thank you very much. I had already thanked everyone, but I had not yet thanked all of you, the participants, those that are attending virtually, and also those that are sitting here. Thank you so much for making this event to be successful. It's not just the event, it's the beginning of a program that would ensure that the maintenance system works. And also, as I said, we want to start a website where fathers who are proud of being fathers would share their stories and pictures where they are going to the mall and whatever with their children, who will show that I pay maintenance without being called to court, so that we can change the mindset of the others. Thank you very much. Lunch is, we go out from here and then you cross over to the other side. Thank you very much.
Thank you, thank you.